Is the service complete? You are appearing on behalf. Okay, you ask somebody when the matter is taken up. You see when the matter reaches. You see when the matter reaches. Huh? Item number 19. At the request of the learned counsel for the petitioner, matters to be listed again on 13th May. Motion? Motion? What do you want? Orders? In the month of May. We'll see when the matter reaches. Motion? Monday. Is this matter before any other bench? See when the matter reaches. When did you file the fresh application? When did you file the fresh application? When did you file the fresh application? For NOC? Then why did you approach this court? Now what is that? Now what do you want? What do you want in this case? You filed it on 23/2. Then, so are you therefore, you filed this petition at a time when you filed this petition on 5/12/2025. Thereupon, you submitted an NOC application for NOC on 23/2/2026. Whether it is done or not, that's a subsequent cause of action. Why should we entertain this type of petition? You cannot put the state into. No, but then also you applied on 23/2. Then why should you? Have you now been allowed to apply or not? So you have now been allowed to apply. You will get it in its own course. Then it will get approved. Why should we look into it now? There might be many other circumstances out there. You have to, if it is not approved, you have an appeal out there. Why should we entertain this type of petitions? Yes, but we are the instructor. No, that is recorded in the order of 25/2. So now, therefore, the, the reason why you have filed the petition is already done. Go before the civil court, ask for damages. Why should we pass on your order? No, Mr. Counsel, as of now, the errors for which you could not file has been rectified. Now the question is on 23/2/2026, you have filed an application. What happens later on, that is a subsequent cause of action. Why should we look into it now? We close this petition, thereby asking you if you are aggrieved by any decision, you can approach the appropriate forum, including this court. That's all. We are not going to put the state into a guillotine out there, thereby saying, okay, a writ is pending out here, so they kindly do it. No, sorry. So go before the civil court, ask for damages there. Not yet. Not such a case by which we are going to exercise our jurisdiction in respect to in the sphere of constitutional thought. Yes. That is, sorry, I can't allow you that. We are to go, I'm going to close this petition with a liberty to you to approach the appropriate forum or this court. If you are aggrieved by if you are aggrieved with the application filed, outcome of the application filed on 23/2/2026, nothing more than that. Now, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioners. Mr. So-and-so appears on behalf of the Revenue Department of the Government of Assam. Mr. Endas appears on behalf of the District Administration. The petitioner had approached this court. Petitioners have approached this court, being aggrieved by the delay in correction of the mutation records. Name correction will also come in the mutation. You have to have your name in the mutation, Mr. Counsel. It may include various other aspects. Your name will be there, everything. So this will include everything. Delay in correction of the mutation records pertaining to the land of the petitioners and and for which the petitioners could not submit their application for obtaining the NOC oblique sale permission for the sale of the land. It has been brought to the attention of this court that in the meanwhile, the corrections have been made and the petitioner thereupon had submitted the application on 23/2/2026, which is apparent from a perusal of the order dated 25/2/2026 of the learned coordinate bench of this court. Considering the above, in the opinion of this court, there is no live cause of action exists in regards the delay in correction of the mutation records. In that view of the matter, the instant writ petition stands closed. However, it is observed that in the circumstance the petitioner is aggrieved by the outcome of the application filed on 23/2/2026 seeking sale commission, the petitioner would be at liberty to approach the appropriate forum, including this court, if so advised. Before parting with the record, this court, however, also finds it pertinent to observe that it is the mandate of Section 21 capital A of the Registration Act 1908, insofar as the same is applicable to the state of Assam, that such applications filed for seeking NOC oblique the sale permission have to be disposed of within a period of 30 days. This court observes that taking into account that the petitioners have now filed the application on 23/2/2026, the respondent authorities shall do the needful in that regard. You want to implead whom? Huh? Of whom? Who is the deceased? Okay. So it's not this is an application filed by the petitioner as applicant seeking the leave of the court to implead the other legal heirs of the petitioner's husband as co-petitioners to the instant. Co-petitioners, do you have any cause of action against them or in favor of them? As respondents to the accompanying writ petition, was taking into account the order passed by this court on 11/3/2026, passed by this court in the accompanying writ petition. It is the opinion of this court that the opposite parties' numbers the 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 persons, the legal heir of the petitioner's husband are included, whose name appears as respondents in the instant application, are arrayed as respondent numbers 3, 4, 5, and 5, 6, and 7 to the accompanying writ petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court. And the registry shall, on the basis thereof, as well as the order passed herein, shall make necessary corrections in the cause title and also update the same in the CIS. I extends this one. The shall file here within 7 days. I extends this post. Wait. Now let us see what is your case. Are you? Where? We have the honor to inform that my husband had purchased the above number vehicle to Tata Finance on here, but at present the husband died on so and so. And thereafter, as nominee, I have paid all the finance. Now the vehicle is being fully financed. Finance clear. Then, but, Mr. Counsel, if you are to apply, you have to apply in a particular form. You don't apply like this. Page. The honor to inform you the vehicle so and so has been blacklisted as per the request of the wife of the owner of the so and so. You are hereby informed that in the order to process any application regarding the remand, the blacklisting of the vehicle is to be removed. Therefore, you are requested to submit proper and valid evidence citing proper reason and understand for removing of the blacklist. Also, I have the honor to inform you that the further process of transfer of ownership application, the following documents are to be submitted. Form 31, you see. You have to file as per Form 31. Registration certificate, identity proof of the transferor and the transferee, death certificate of the actual owner, next of the kin certificate, NOC from all other legal heirs. So, Mr. Counsel, your dispute is between you and the newly impleaded. Fantastic. So, if that be so, why should we, under 226, exercise our jurisdiction? You should be happy the first application I allowed. Understood. That is a dispute between you and them. Fight it out. Somewhere. I can't help you. You do one thing. I close this petition on the basis that you will provide these documents to them. In the meantime, fight it out. That is the win-win. Because you cannot on that basis of that application seek transfer. You have to submit a Form 31. That is one. The other documents you have a problem with the NOC. I would not bring into aspect about the NSC aspect. You have a next of kin. Next of kin, their names is also appearing. So therefore, you have to get the NOC. Can't help it. This is the law. Tomorrow they will claim. And there can be only registration of 1% or 2%. So you compete with them. And if they don't allow, we are not here to say, how do we know that you finance everything? You have paid all the other things. How do I know? Your husband died in 2021. Why on earth after 5 years you have just thought it okay, let us do it? Very good. Okay. We then close it. You already put it. Heard Mr. S.C. Biswas, the learned counsel, appearing on behalf of the petitioner. It's M.D. Bora, who appears on behalf of the Transport Department of the Government of Assam. The petitioner had approached this court seeking a direction upon the Transport Department, the concerned, seeking a direction upon the respondent number 2 for registering the vehicle bearing registration number AS19K 8157 in her name after the demise of her husband. It is the case of the petitioner that on 21/1/2026, representation was submitted to the respondent number 2. However, the same have not been taken note of, have not been considered, and it is under such circumstances the petitioner had approached this court by filing the writ petition. This court also takes note of the additional affidavit filed by the petitioner wherein it is mentioned that the representations so submitted on 21/1/2026 have been disposed of, directing the petitioner to submit an application in form number 31. That is what I have recorded that form number 31, along with all other documents, including the NOCs from all legal heirs regarding the transfer. The counsel appearing on behalf of the petitioner submitted that he has no problem in providing the documents as mentioned at serial number 1 to 5 of the communication dated 18/2/2026. However, the petitioner has the problem in getting the NOC from all other legal heirs regarding transfer. Taking into account the said submission, it appears therefore that the dispute in question primarily lies between the petitioner and the private respondents. As to the ownership of the vehicle in question, this dispute cannot be decided by this court in exercise of the powers under Article 2 to 6 of the Constitution. On the ground that the adjudication of such dispute would require deciding on various factual aspects. Apart from that, it is purely a private dispute between the petitioner and the private respondents. Considering the above, this court therefore is not inclined to entertain the instant writ petition. However, this court observes that not entertaining the instant writ petition shall not preclude or prejudice the petitioner to approach the appropriate forum or arrive at a conciliation between the petitioner and the private respondents. It is further observed that in the circumstance, the petitioner is able to obtain the NOC from all the legal heirs regarding the transfer. The respondent authorities shall take appropriate steps in consonance with the communication dated 18/2/2026. So you file your memo particles. Yes, what is this? Why should we enter? Why on earth we should entertain their dispute between you and some private respondent and trouble Mr. S. Bora to do so? If they don't do, don't do. They pass an order, they don't want their orders to be recognized or do anything. They have not bothered. They say that we pass orders, but which orders are toothless, or it may have some tooth when we are interested. You are only question, you have come before this court only on the ground that look here, they have passed an order, but the arbitrary action on the part of the GMC is that these orders become toothless when the GMC authorities are not interested and have the tooth when they are interested. Your cases must be that. What is this? Otherwise, you are going to do it. Otherwise, you are going to do it. Then close it. It's a private dispute between you and the government. Somebody else. You are paying for the private one. 4567. You are asking for implementation of the order dated 2/3/2026. But they have fixed it on 7/3. But GMD authorities knew that the election is coming. So therefore they postponed it, although the Election Commission knew that they are issuing the notification on 15/3. Something like that. No? We are closing it. We are not going to do this. Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Mr. S. Bora appears on behalf of the respondent numbers 1, 2, 3, full stop. Municipal, Ms. M. Bormon appears for respondent number 1, 2, and 3. The petitioners herein are aggrieved by the inaction on the part of the respondent number 2 and 3 in taking effective steps pursuant to the orders dated 19/11/2025, as well as the order dated 2/3/2026, issued by the Chief Executive Officer of the Gauhati Metropolitan Development Authority. Upon the matter being taken up, Mr. S. Bora, the learned counsel appearing on behalf of the GMDA, submitted that the GMD authorities have not taken any steps presently on account of the Assam State Legislative Elections 2026, as well as the implementation of the Model Code of Conduct. He further submits that after the Model Code of Conduct is over, due steps would be taken by the GMD authorities. In that regard, he has placed before this court an instruction dated 31/3/2026 issued by the Chief Executive Officer of the Gauhati of the GMDA. The same is kept on record and marked with the letter X, taking into account that the GMDA would be taking steps for carrying out the demolition in terms with the order dated 19/11/2025, as well as the demolition order dated 2/3/2026, and the statements so made by the Standing Council of the GMDA. This court does not find the present case as a fit case for issuance of notice for the present. Accordingly, this court closes the instant writ petition. So it is, however, observed that in the circumstance, no actions are being taken by the GMD authorities pursuant to the Model Code of Conduct being over. The petitioner would be at liberty to again approach this court. So advise. What is this? But where the impugn order? Now, you have the CGST Act. Kindly come to section 75(4). What does it say? 75(6). What does it say? Anything given? No, this is not a technical point. This is the mandate of the statute. 73, notice. DRC 01A. But if you look into the provisions of 142, Rule 142, we do one thing. Why should we keep this matter pending? We set aside and we go ahead, we do it. And another thing, as we are exercising the jurisdiction under 226, and they have approached us for the first time now, the period from 30/3/2024 till date shall be excluded. We take action under 73, 74, 74A. That is your lookout. That is for hearing. Construction. And we therefore give him from that time. Because you see, the thing is, you have approached this court. Did you file an appeal? So you are approaching this court after 2 years. Is it pending for how many years? 2 years? Oh, on that ground, I think we should dismiss with petition. Huh? No, keeping it pending from, you filed it on 13/3/2026. Then why an order which is passed on 30/3/2024, you are challenging it today? What? You filed a petition on 13/3/2026. I'm saying about 2024 order. Madam, are you telling me that after having so many years of practice, you are not aware what are the defects to be cured? It's a very sad state of affairs, madam. Keeping it pending for all these years out here to showing out. So therefore, we take into it, you give an undertaking. What? Because the delay appeal 107, he cannot file an appeal, therefore we have approved this form. We should dismiss 107. No. Why should we? Think, think we should dismiss. Don't you think, Mr. Boyd? Abuse? Cost? How much is the amount? 25% on that is the cost amount. Oh, this is an order under 74. Fraud, suppression, evasion of tax. Isn't it the mention out there categorically? Mr. Gogo, kindly read section 74(1). This is a case falling under what? 74(1). No. This is a case of fraud. 74(1). I'm not going to do that. Yes, Mr. Gogo. Fraud, suppression of material facts, and in order to evade taxes. Golden words. Summary of the so-called says that the taxpayer has filed GST 9 and on scrutiny of the returns for the period 2017-18 along with other relevant documents available in this office, anomalies were observed which were mentioned in the ground given the hearing. Ground the excess input tax credit claim on account of non-reconciliation of the information. It is seen that the GST 9 and other information that they have claimed ITC on these commodities and taxes in the due. Therefore, date on which reply is to be submitted. Did you submit your reply? Huh? Where? Reply to the so-called. Notice has no dispute on the reversal of wrong so and so. Notice voluntarily reverse the whole wrongful credit of IPC and CDST and not to so and so and they retain into the oversight in no penal proceedings are warranted in the present case as the notice has mistakenly availed IPC. So this your reply is there. Then wait. Then what happened? Then DRC the 01 summary of another source. This is 1780. Now what is the reason given? Paid the tax after the due date. So thereby you have not paid the interest. Now in this particular thing, did you impose the year? Yes. So you have paid only 1,99,000. You have only paid the tax, not the others. This is your self-statement. But then, Mr. Gokoi, kindly see section 7512. No, kindly see section 7512. No regret. Interest or not. So they duly admit. But you can very well recover under 79. Why do you have to go under 74? Recover it. Recover it. We dismiss your case. What? Not necessary. No, why do you have to go to 74? 75 12 says not necessary to go to 73, 74 or 74A. Isn't it? Yeah. You go under 79 and take it off. Madam, if the moment as per 74.5, if the moment it is not doesn't comes under 74, it will automatically come under 73. Then not time bar. That can be done if it is not found. No, you have if you have acquisition, no possible. We constitute 73 and go ahead. No, You have already given your reply out there. In fact, it was not necessary for issuance of these notices. You kindly see why. My question is this. Kindly see this. We are concerned with 2017-18. Kindly come to this election. This is not required because of this. Kindly see the scope of notice at page 70. Herein it says that when you are filing the GSTR 9, you have wrongly availed such an ITC. Isn't it? I'm actually asking. It is categorically says that you have wrongly paid the ITC. You admit. And in this particular notice, it is mentioned that this is a notice under 73. In this notice, it is mentioned that look here, in the ITC which you have claimed, you have categorically mentioned out there for this particular period, this is the tax, this is the penalty, and this is the interest. It has been mentioned what is the tax period, how much, and GST, tax, and interest. Number 9 is interest, no? 9 is the interest. Okay. 9 being the interest out there, they have not imposed penalty upon you. That is another very good thing. But it is an interest. Now you categorically say that yes, there was a mistake in wrongly availing. Kindly see your reply. At page 82. You categorically say that I have wrongly availed. Now, if you that means the moment you are saying that the ITC amount has been wrongly paid, wrongly availed, means yes, it may not be a case of a year, but your self-admission is there to that effect that it is so. Then why the interest is not liable then? Because otherwise, if we consider that you are saying that no interest is leviable, forget about all other proceedings. These are all consequential. They can, because 79 does not mention a period, isn't it? 1,99,000. No, the total amount is 9 lakhs. Interest is 9 lakhs. Where? Hmm. Hmm. So here the notice was given to you under under this particular thing, and we have replied also separately. No, 74 notice was also given to you. No. Kindly come to this notice. You kindly see the notice which has been issued at page 89. This is a notice which has been given to you. Understood. Now they have given this thing. You see, when the notice was initially issued under 73, you were saying that this is the particular amount you are likely to pay. You only paid the tax but did not pay the interest. No. But madam, tell me, the moment you are saying that this particular amount is the tax which you should have paid, but on account of availing of the ITC, you did not pay. That is your specific case out at page 82. No, 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 no. No, no, you don't say that. You say, kindly see, the noticee voluntarily reversed the wrongful availment of ITC and CGST amounting to rupees so and so due to oversight filing, as the concerned person had no knowledge of the blocked ITC during the material period. Meaning thereby the ITC, the moment, you see, why do you use the ITC? The ITC is as like a set off to the payment of taxes. So therefore, the moment you take away the ITC out there, you are not paying this 1,99,000 and all. The moment you are reversing it, you may have to pay it. Now, because of not paying the tax, within that period, the amount was around 9 lakhs. They have imposed the interest. You therefore say, kindly see here, the difference was due to the inadvertent filing of the GST returns in the GST portal. The notice is depositing the delayed payment interest after calculating in due course. Now you clearly see this. The notice is depositing the delayed payment after calculating the same in due course, meaning thereby you undertake that you are going to make the payment of that. No, I'm asking you this. So therefore, what you are trying to submit, madam, you should know I did a little bit of tax also. So therefore, you should know that not to make that submission to that effect that I have reversed it. I know, but the moment you have reversed it, you are liable because you have already taken the ITC for your set off. So therefore, now you have categorically said that page 82 that look here, I'm going to deposit this interest. Now, did you deposit? Did you deposit the 9 lakhs? No, no, no. This is what has been mentioned. Submits that they have complied with the requirement of so and so, and therefore no penal proceedings should be initiated. Meaning thereby the penalty proceedings separately kindly don't initiate. This is a 73. So at that point of time, this 9 lakh amount was required to be paid as on 3/10/2023. You did not pay that. And therefore now this is being noticed, this is being given out here. Kindly, this is an interesting notice, page 93. No, I'm not on interest on interest. Wait. Madam, you have to also understand. You have to also understand one thing. Let us see. You see, normally when it comes to any decretal amount, or as per the Contract Act, if you see, first the amount has to be, whenever you pay a particular amount, that amount has to be adjusted against the interest, then cost, then to the principal. Now, what you have done, yes, that is the law. Normal. I don't know here. Let me look into section 50. But otherwise, here what you have done, you paid the tax. No, no, you paid the tax, but not paid the interest on the ground, thinking that there cannot be any interest on interest. Wait, and let's come to section 50. Every person who is liable to pay tax in accordance with the provisions of this act or the rules mandate, but fails to pay the tax or any part thereof to the government within the period prescribed, shall for the period for which the tax or any part thereof remains unpaid, pay on its own interest at such rate not exceeding 18% as notified by the government layer, provided the interest and tax payable in respect to the supplies made during a tax period and declared in the return for the said period furnished after the due date in accordance with the provision here, except where such return is furnished at the commencement of proceedings preliminary shall be payable on that portion of the tax which is paid by debiting the electronic tax. The interest on the subject shall be calculated in such manner as may be prescribed from the day succeeding the day on which the tax was due and paid. Where the input tax credit have been wrongly availed and utilized, the registered person shall pay the interest on such input tax wrongly availed and utilized at such rate not exceeding 24%, as may be notified on a recommendation of the yes. So what do you want to say here? No, no, we are concerned. No, we are concerned with 53 as it came in Finance Act 2022. Finally come to penalty where the input tax credit has been wrongly evaded and utilized, which you have done. You have done. What? You availed the wrongful amendment. This is your admission at page 82. This is your own admission. Therefore, you are saying that I am reversed. Why will you reverse if you have not availed or utilized? Kindly come to page 82. This is your own submission. Stand at 82. But have no dispute on reversal of the wrong availment of the year for the financial year. No, you therefore, you see, when you are going to reverse, you are going to reverse only when you have utilized. And you see, the noticee voluntarily reversed the wrongful availment of expense. Yes, please. But Mr. Counsel, tell me one thing. When do you reverse? Can you reverse if you have not utilized? But Mr. Counsel, tell me, one is avail. You are saying that I have to, one line. I should have in my electronic ledger 1 lakh, but wrongly while mentioning in my returns or whatever may be, I have shown it 10. But you have not used it. That is, it would come within the ambit of availing. No, it won't come within the ambit of availing. It would neither come for the amount of availing because he has not used it. How do you say so? Now, where do you get the meaning of availing? It's, every registered shall subject to such conditions as may be prescribed be entitled to avail the credit of the interested in return in such amount shall have the interest. So therefore, the question is like this. He has some input tax credit, which he has to put it in his return filed under 39. And thereby it will be shown in the electronic ledger that this is the amount which has been, I have the input tax, not away, the whatever the input tax credit which was there from all this business which I have, but at the moment when we file the return, this is the amount which is to be shown that I have this input tax credit. Because that is means he is showing it in his returns could mean availing. Availing. Not now the moment against the tax, there's a set off in view of the availment of the input tax credit. That would mean utilization. Hmm. Now, there might be a case of wrongful availment. No, I'm saying there might be a case of wrongful availment by showing it in my GST returns. But the moment I utilize that, the moment I utilize a wrongful availed ITC in the my GST returns towards the payment of tax, then the tax would be at the rate of 24%. Interest at 24%. The government says that you have to avail and utilize. Government doesn't say if you don't utilize, but you says that the twin conditions of availment and utilization. But there cannot be utilization without an availment. How is they can? Because there you are only showing it in your GST returns. Now the question is, did you make any payment of the tax? Now, did you make any payment of the tax? No. My question is, here you see, my question is, You file an additional affidavit. No, but my question here is, no, one interesting aspect. 73 proceedings were initiated as regards reversal of the input tax bill. And there was a tax in case of 9 law. It is not. But in the 74 notice, which is being issued on 17/11, this is not, this doesn't have any connection with the ITC. Maybe same year, but this is 74 is being done. Because, no, we have done, see, 73, this is the summary of so-called at page 70. Here says that the excess input paid claimed on account of non-reconciliation of the information received the GST and 9 and other information that they have claimed ITC on these commodities and therefore the ITC claim on the services proposed to be recovered. This is at page 70. Thereupon, the amount which is being put out here, the tax amount can you see is 1,99,000 at page 72. And a corresponding interest which is put at 9,96,000. Isn't it? Okay. So therefore, you were asked to pay 11,95,000. Now, what happened? You finally come to page 74. No, wait. Page 75. Wait. Maybe officer. Finally, you have filed the annual GST return for the financial year on examination of the return at so and so. Summary is 9 lakh so and so amount. The details of the amount is excess claim away, excess so and so claimed on account of reconciliation under so and so has not correctly availed the input tax on his onward supplies and CST 9. Now, this is what is given out here. ITC in the year so and so ITC, these have been given. Net excess is so and so. Now, this happened there. Then you have another aspect, total tax due in excess claim of ITC. Now, kindly see page 79. In the total tax due for ITC means you have availed and utilized. Therefore, they are asking this amount. Now, anyway, let us not forget to that. Now, you therefore say that we have reversed it and we are going to pay the tax. So, this is on this 9 lakhs. Now, therefore, thereafter you find this so-called notice on 17/11/2023. This is subsequently. Now, here they say that you have filed a GSTR 3B. Now, here the tax amount is different. Kindly see. 2,77,031. Again, for CGST, it's so and so. Interest, this is the text summary of the so-called notice on 17/11. Okay, here there is no interest. Now here you see another notice which have been issued. Now this is a notice pertaining to that you have claimed the GSTR, that particular amount is the tax payable and you have not paid. Now therefore you have an IGST component here. Kindly see here. Interest payable on this 2,77,000. This has nothing to do that with 1,99,000. This appears to be something. Now, here the case is on a different asset. This is not on the ITC. ITC, you might have paid this 9 lakhs. We don't know what has happened. But here is a case they are asking on this 2,77,000, which is not a part of that ITC. This is, under so and so, you have and declared the return for the said period furnished after the due date. So this is the return furnished and this is the amount payable. CGST as well as SGST, this amount, and so and so and so and so, IGST amount. This is not interest payable on these amount. It is at page 89, 90. This is the page 90. It is there, madam. Page 88 is there and page 90. Page 90. So it is under such circumstances, you are therefore asked to submit a reply on 17/12. Supporting document attached by the officer. Interest notice under so and so. So this page 89 becomes a part of this summary to the show cause. What interest is not there? It is category. Kindly come to page 70, 90. No, no, it is not so. No, man. Kindly see, this is the amount which they are showing. Interest, tax, so and so. This is the tax and interest is number 9. No. Then you find any side the interest notice, which is at page 89. Wait, kindly come. That is an attached document. It is you, madam, you have made that mistake, not the officials. This is page 89. Yeah, I understand. Now kindly see. Under 50, this is being shown. This is the after due date. This has nothing to do with input tax credit. No, it appears so. Then you kindly see, this is the notice. You have filed the year. Again, you find the same thing. The same page 89 is again seen it at page 92. Now, therefore, they say that in the GST return, you categorically mention that this is the tax payable. Why not we take action under 7512 and take action under 79? Because then you don't need to go for 74 or anything. And now your reply kindly see, and you see page 92. Date of the filing of the GSTR, these are filed in the year 2019. Delay in filing in so and so, rate of interest is 18%, HGST in month, TGST in month, IGST in month. So total tax says paid in cash or so and so, says so and so is total in month, says interest payable on this amount. Means you have filed your GST return lately, and this is the resultant why the amount comes to this 30 lakhs. Page 94, page 94. That is how the calculation comes. Now, what do you say out here? Now, you kindly see your reply, page 95. We are in receipt of your notice, you reply in so and so, thank you, so and support and favorable for the document uploaded. Now, this is there. Here you say that for the Iman under section 1979, kindly don't take any action. And now you say it is time barred. Where you, so you therefore admit that you could not on account of the GST glitches. No, when it is there, it's given at page 94. So they wanted to take action under 79. They could have taken action under 79, but what they made the mistake is now they have again turned to. Now, therefore, they have issued this DRC 07 because they are doing it under 79, not under 74. That is why the interest is there. You therefore have to see this page 101 with this page 92. Then you understand this. You thought that simple 74 notice not given. Because it is not, they are not exercising 74. They are doing it under 79. Isn't it, Mr. Bugoi? You have also not looked into. And she has brought all these IPC aspect unnecessary. That is not the case anywhere. She is now challenging the DRC 097. They are challenging the DRC 07, and she knows it very well, therefore kept the matter pending like. Otherwise, why on earth a person will file after 2 years? Absolutely no. You filed on 13/3/2026. So therefore, the limitation which is given under 74(9) or 73(9) would not apply, because this is a self-admission which is done in the GSTR, and they have failed to, they delayed in depositing the taxes and all. This is whatever may be for GST portal or whatever may be, they have delayed, and the resultant, this is the delay, which is at page 94. Not additional affidavit. No, initially they took 73. Action under 73. And you said, okay, we are depositing. And most probably we must have deposited the 9 lakhs. That is there. I think if we look it closely on these particular documents at later on at page, she have put it also, you could see 76, 77, this type copy properly, then you will get to know what how it is. Because they say that notice is depositing the delayed payment of interest after calculating the same. Categorically says. This happened on 310. And most probably they have deposited. Then comes the second notice on the 1711. Upon hearing the learned counsel appearing on behalf of the petition, this court inquired with the learned counsel as regards the correlation with the Choco's notice issued on 29/9/2023 with the Choco's notice issued on 17/11/2023. Inasmuch as in the Choco's notice dated 29/9/2023, it appears that there was a wrong utilization. There was a excess. In as much as the Choco's notice dated 29/9/2023 refers to excess input tax claimed, whereas in respect to the Choco's notice which was issued on 17/11/2023, it relates to delayed payment of tax pursuant to the returns filed under GSTR 3B. And on which it is further seen from a very perusal of annexure Roman 7, Roman 8, and Roman 9 that the said action which has been taken appears to be in consonance with section in taken is on the basis of section 75(12) of the Assam Goods and Service Tax Act 2017. and further steps being taken in terms with Section 79 of the said Act. Ms. N. Havelia, the learned counsel appearing on behalf of the petitioner, submits that you obtain necessary instructions in that regard and place it by way of an additional affidavit. When do you want, madam? List this matter again on. This court further observed that it is only upon satisfaction of these aspects by way of an affidavit, by way of the additional satisfaction as regards the aforementioned aspect, notices can be issued in the instant proceedings. List this matter again on 22nd of April 2006. What? I've not issued a notice. You are asking for interim. My goodness. Yes, madam. Children? Wait, wait. Page 86. Therefore, you are asked to show cause or not remand why the amount mentioned above should not be realized from you. Please note that the event of failure to comply with the so and so, this notice would be issued. Now, therefore, this is the show cause notice. They must have given you a DRC 01A. DRC 01 has been given. You have filed your GSTR 9 financial year 2021-22. Live. Then so called notice is issued on page 62. Why you are making all this, everything else? They can very well look into it. . So on 27 to 2025, you have been issued a 74 notice. 74, page 62. No, no, why you have not enclosed? Kindly see page 79. This is the so-called notice in summary under DRC 01. This is by the Assistant Commissioner of the Jurisdiction to so and so. Act CGST Act. April 2 to so and so, so-called notice dated 27 to 2000, date so and so. Copy of the detailed notice is enclosed in a separate attachment. Kindly page C81. Isn't it? Why haven't you enclosed that document? So therefore, why you are saying that this is the same? Where? Page 62 is, page 62 is in connection with what? Where is the DRC one? Now, in pursuance to the supposed notice, whereas the notice on the so and so, read with the concurrent provisions of so and so is hereby issued to so and so to show forth. Why GST determined hearing should not be recovered along with interest under section 50 and applicable penalties under 74 and 112 of the CGST Act should not be imposed. Intelligence gathered so and so. There it is there for this slip and everything. Another summons has been issued, quantification given everything. Along with that, this is for 2022-23. Now, page 62 is for 2023, 22-23. I'm not on that. Page 62 is a show cause notice issued for 2022-23. Because if you see at page 66, the amount which is being said to be 76 lakhs and all, arises for the details pertaining to from April 2022 to July 2022. What is the date of this document? 27 to 2025. This is by the central GST. Now kindly see this. No, wait. Kindly come to page 66, paragraph 9. From the above, it appears so and so have involved in clandestine removal of goods without issuing GST invoice and applicable GST of rupees so and so 38 lakhs 10,468. Now you kindly come to DRC 01, page 79, and kindly come to page 81. This is the amount which is being mentioned out there. Page, period 2022-23, 38 lakhs. 38 lakhs. So total comes to this. Huh? You are not challenging. Why are you including both? No, are you saying that you have paid more than that? No, I'm not on that. Your total demand is 76 lakhs. Paid? This is for the period from 21-22. 21-22, this is the summary of the so-called eligible ITC. So 2022-23, where we are not concerned. Okay, chalo. So we are concerned with April 2021-22. So here the tax which have been imposed of the DRC 01 has been given to the effect that 30 lakhs tax for tax and CGST is, huh? Huh. Yes, it has been given the report why it is so. Yes. Kindly see, integrated tax is 30 lakhs, which is being put out here. IGST, they have put it. Kindly come to page 89. 30 lakhs to the tax, 5 lakhs and 5 lakhs. Okay. Where do you say the final order is passed on 26 September? No, see, this is the audit department stating as regards that your books of account of so and so have been examined and this audit report is prepared on the basis of the information available. And they say that this amount is given out there of which penalty and so and so. On the basis of this document, this DRC 01 has been included. Now, wait. Now, here you have a show cause notice issued. Page 88. No, no, no. A so-called notice has been issued at page 88. Where's the supporting document for 88? No, no. Page 91 is your reply, madam. Where is the document for this so-called notice, which is there as a PDF? Is there supporting attached by a so-called notice PDF? Where's the document? No, you have replied to that. Therefore, you say a detailed reply is being provided, is being attached, DSPR so and so, so and so, so and so. Now kindly see this document. We are in receipt of the so-called notice in the earth to the so-called as to why the demand of so and so should not be levied. Now, IPC claimed out there so and so claim of Iman who has not filed a Jan TV. Claim of ineligible if uploaded by the year who have not filed TV. You have not claimed that you have not understood the so-called notice we have given. Would reply to that. No interest, no payment of interest due to delayed payment of tax or the revert charge. No so and so. File appeal. Why should we exercise this? No, sorry. No, no, no. You file your appeal. No, I am not going to exercise this type of jurisdiction. Sorry. No, 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 no. No. File appeal under 107. All these things will be looked into. This court is not going to go into. In fact, in the earlier matter also, I think we should have sent it on appeal. What do you say, Mr. Gogoi? Earlier matter also should have gone on appeal. Because no, not only that. You see, these things are being brought in where this court is directed to look into it. Unnecessary things. Just for example, why they are brought into in 2022-23, which have no relevance out here in a matter of 2021-22. We are not going to exercise this jurisdiction. Whatever may be, you go there. Sorry, we don't find there is any violation of any treaty. You go there. Heard Miss N. Havelia, the learned counsel appeared. And heard N. Havelia, the learned counsel appearing on behalf of the petitioner. Mr. So appears on behalf of the respondent numbers 1 to 5. The present petition has been filed by the petitioner assailing the order dated 31/12/2025, passed by the respondent number 3. Respondent number 3. Mr. Kyle, you appear for this CGST? Okay. So and so appears for AR, respondent number 1, 1, 2, and no 1, 2, and 3. 1, 2, and 5. Now order is passed by the respondent number 3. 1, 2, and 3. Mr. So and so appears for respondent number 4. Mr. FC Kyle appears for respondent number 5. The present petition has been filed by the petitioner assailing the order dated 30/12/2025, passed by the respondent number 3 in exercise of jurisdiction under section 73 of the Assam, Assam was seriously under the 73 of the Assam Goods and Service Tax Act 2017. Which the grievance of the petitioner by approaching this court by invoking the extraordinary jurisdiction under Article 2 to 6 of the Constitution is that there was no proper notice issued under Section 73 of the Assam GST Act 2017. And it was only on the basis of a summary of a show cause notice issued under DRC 01, the proceedings under Section 73 of the Assam GST Act 2017 was initiated and concluded. This could have duly perused the summary of the show cause notice issued on 26/9/2025 for the financial year 2021-22. And a perusal thereof reveals that there were two documents which have been enclosed, one of which is the show cause notice. However, the said show cause notice have not been enclosed to the petition. Huh? No, show cause. Show cause notice. The said show cause notice is an annexure Roman 5 to the petition. This could have also perused that the petitioner was afforded an opportunity to submit a reply to the said show cause notice. And the petitioner had duly submitted a reply on 11/10/2025, wherein nothing has been mentioned that the petitioner could not understand the purport of the show cause notice which was issued to the petitioner on 26/9/2025. Thereupon, the order was passed by the respondent number 3 on 30/12/2025. Taking into account that there is no violation either to the provisions of the principles of natural justice or the mandate or the statutory mandate of the Assam Goods and Service Tax Act 2017 and the rules, this court does not find the present case to be a fit case to be entertained under Article 2 to 6 of the Constitution, taking into account that the petitioner has an efficacious, alternative and efficacious remedy provided under Section 107 of the Assam Goods and Service Tax Act 2017. This court further takes note of that the instant petition was filed on 30/1/2026, and taking into account that the petitioner under a bona fide belief had approached this court and by filing the instant petition, this court observes that a period from 30/1/2026 till date be excluded while computing the period of limitation for filing the appeal under Section 107 of the Assam General Estates Goods and Service Tax Act. The interim orders passed earlier extensively. What it is, Mr. Counsel? Appropriate steps for correcting the land records in respect to period number in one. Did you file online? Understood, but how is it possible for correction if you don't file online? You have to file online. Is it possible to file offline? Mr. Counsel, just one. No. My question is, what is the name of the patada? Late Zolia Dhihingia, oblique Molia Dhihingia. Yes. Those are the persons whose names have been wrongly inserted. So your name, your father's name. For whom? Okay. So, okay, then you do one thing. Have you paid? Where your document to show that you are the owner? The council. Where is the document to show that you are the owner? Mr. Counsel, have you ever seen a revenue, land revenue receipt? Have you seen it? No, no, have you seen it? Very well. No, therefore, you have seen it. What are the contents of a land revenue receipt? Name of the patadar, for whom paid. Number two. No, but where's your name earlier, your father's name earlier, or your name earlier? No, no, Mr. Counsel, Mr. Counsel, I don't take to appreciate. Where is your father's name in the land or your name in the land earlier? So therefore, from 1970 onwards, there's no mention. Now, how? To whom? No, no, in whose name have you purchased? For whom you have purchased? Yes. There are 12 under and the names only are mentioned we have not been based out from the year. The said has been under possession and employment of streaming. Okay, you do one thing. You produce the, you have been paying tax now for last 25 years. Very good. So produce type revenue receipts by filing an additional. Then we'll look. It has been submitted by the learned counsel appearing on behalf of the petitioner that the petitioner have been paying the land revenue in respect to the land in question since many years. And this very aspect would be apparent from a perusal of Annex 16 to the petition, page 16 to the petition. Taking into account that the petitioner have not enclosed any document to show the petitioner's ownership over the land, it is the opinion of this court that this court cannot it is the opinion of this court that the requisites for issuance of a notice is not met unless and until can be a satisfaction that the petitioner is the owner of the land in question and he has been paying the revenue. This matter how much time? This is matter again on 4th of May 2026. In the meantime, by way of an additional affidavit, the petitioner shall bring on record such documents which should show that the petitioner's ownership over the land in question, and further, as to whether the petitioner further the land revenue payment receipts for at least 5 years prior to the issuance of the communication dated, the issuance of Annexure 1 dated 30/10/2020. What is this? Cancellation. What ground? Well, we allow this cancellation of registration. Huh? Yes, Vidya, the moment I see you, I just remember Rose Candy. Yes. What is this matter, Bob? Who is to pay? State. Oh, oh, well, Justice Chaudhary is taking up something of a similar type. Against that car, which is from Bhutan. Then my question is, if there is an agreement, why the why the tribunal is not taking any action? No, no, the tribunal has also passed on a direction for initiating bacteria proceedings. Now what happened? It doesn't have the jurisdiction. So the question is, the time of passing of the award, this respect to looking to whether service was met in a equal party. How whom should we issue the writ? Huh? In the central government, the party. Yes, what do you have to do? How can we take to resolve those issues? No, one the most important aspect, I don't think this is a case coming under the Ministry of Laws, but I think it has to be brought within the Ministry of Law. What is there? What is there in physical infrastructure? I think we do one thing. We don't issue notice upon the respondent number 4 and 5 for the time being. We don't. We ask the central government to explore how can it be settled and bring it to us. Because you see, you have an agreement. And therefore you can get it done. Because what has happened is this is an awarded amount. There is an agreement. So the Ministry of External Affairs needs to be brought into the picture, although this is their external affairs will also have to. Don't you think the Ministry of External Affairs also has? Do one thing. File an application to empty the Ministry of External Affairs. There. Or Secretary Ministry of Affairs. So therefore, 1 and 2, we issue notice to 1, 2, and 3, okay, let her be happy with the notice. Otherwise, she has no business. She can't do it. I think it is that to be done as per the. Because another very important aspect which I could see after the 2019 amendment, like just for example, if I have to go to, if I take my car outside from here to park, or even Bangladesh and all, we have to have an insurance. The geographical insurance in that. And this geographical insurance is permitted on the basis of this agreement. Otherwise, an insurance company, or just for example, the Bajaj Alliance Insurance Company cannot give a geographical coverage out there in Nepal or in states. Now, if the accident happens in Nepal, this insurance company would indemnify because the geographically it has been, there is always a modification. If you have your car out there, you want to go to Nepal, you can get this thing done. There's no problem. I've seen it in the person. So if that is so, we need to therefore bring in the Ministry of Aid. We don't issue notice because you see, issuance of notice now to the Bhutanese government may not be proper. We'll do it later on if need be. First, I think to see as to how it can be done. We issue notice to 1, 2. You want the notice? He also doesn't. See, notice on the respondent number 1 and 2 returnable by 8th of June 2026. For the present, this court is not inclined to issue notice upon the other respondents, which shall be considered if so need be, if need arises at a later stage. Petitioners herein are claimants in respect to an award passed by the learned Motor Accidents Claims Tribunal number 1, Kamruk Metro at Gauhati in MAC case number 243 of 2017. The accident which occurred was on account of occurred was due to a vehicle which is registered on the Kingdom of Bhutan or what? In the Kingdom of Bhutan, bearing registration number PP2A oblique 5737. Within the territorial jurisdiction of India. This court, the petitioners herein are agreed that agreed on account of the non-satisfaction of the said award dated 10/12/2021 in MSC case number 243 of 2017 on the ground that the award cannot not being implemented and is not being executed. In spite of there being an agreement between the governments of the People's Republic of Bangladesh, the Kingdom of Bhutan, the Republic of India, and Nepal. Relating to motor vehicles for regulation of passengers, personnel, and cargo vehicular traffic. Taking into account the above, it extra copy to the I think it actually is something else. Taking into account the above, this court therefore would like to know the stand of this respondent number 1 and 2 as to how the award can be implemented. What dated so and so passed in MSC's case numbers which can be implemented. In terms with the award, in terms with the motor vehicles agreement for regulation of passenger, personnel, and cargo vehicular traffic between Bangladesh, Bhutan, India, and Nepal. The affidavit be filed on or before 1st of June 2026. Yeah. So then you file the demarcation. Now the demarcation application, when did you file it? Huh? Then who is in possession? So file a suit. Why should we? What is your prayer? After his demise, the land has already been mutated in the name of the applicants by mutation number. However, despite several applications, the demarcation and handing over of the possession means you are not in possession. So you want this court to handing over possession in respect to some other people who are residing? Sorry, I don't exercise such statement. We dismiss, go to the civil court. If somebody else is in possession. No, nothing doing. You have to give. You cannot ask this type of thing. You want, okay, kindly show me the land. That's a different issue. But you are not in possession. If you are in possession, then the question is different. You should know who are actually in possession. Who is in possession? You know somebody else. You know who is in possession. Who is in possession, you know. How did you get the land? So you have the four boundaries. You have the four boundaries. You have the four boundaries. You also have the dark number. You can very well go and see in the revenue map where the dark number is and where is the land. The mandal will show you. That's all. They can, but if there's somebody else who are asking for a handing over by possession, but you know which dark number, then you know that the land measuring two katha covered by so and so by virtue of the registered sale deed. So this was purchased. What is the number of the sale deed? Sale deed is of 2012. Then, then you got yourself mutated. Now you want the demarcation to the land. You have not made the other people a party. You know where the land is. Are you? Don't you know? Should be the sale deed. A plot of land of Panchan measure so and so. Plot of land of Connectwell so that. Plot of land of so and so. So you know where the land is. Where you need a demarcation. I've seen it. You know the land. Where is it? Go and find out. Why should you travel them? It also says that if there is a dispute, there shall be no demarcation. So, and hand over the possession what you have mentioned. There's something fishy, Mr. Boroman. Okay, you just find out what is the fishiness about. You should notice. No, nothing. Mr. Roman. Mr. Roman, I have been sitting in bench 5 for quite a long time. I know where you are going. You should notice making it returnable on 13th of May 2026. Mr. Eberchedi accepts notice on behalf of respondent numbers 1 and 2. And Mr. Surenso accepts notice on behalf of the respondent number 3 and 4. The case of the petitioner herein, the petitioner is the owner of a plot of land at measuring 2 kotha 10 lechas covered by dark number 555 of KP Pata number 252 of Nagorbera, Ismat under Nagorbera Moja in the district of Kamrup. Metro or Assam? Kamrup. Kamrup rural. Kamrup, Assam. Pursuant to an order passed by the court in Demolition number 32, order dated 18/7/2025, in Demolition number 3209 of the 2025, the land was mutated in the name of the petition. And thereupon, name of the petitioner as well as her sons. And thereupon, the petitioner sought for an application, filed an application seeking demarcation of the said land on 15/9/2025. The same having not been considered, the petitioner has approached this court. This court have also perused the communication, the applications were filed on 15/9/2025, wherein it appears the petitioners have not only sought for demarcation of the land, but also handing over the possession of the land. The question, however, therefore arises that there might be some other persons who may have been in possession of the land. Be that as it may, this court directs the respondents, more particularly the respondent number 3 and 4, to apply this court by way of an affidavit as to why the land wherein the petitioner has sought for demarcation have not, no demarcation proceedings have been initiated. This court further observes that pendency of the instant petition, pending next date, it shall not be a bar on the part of the respondent number 4 to initiate the process of demarcation. But just by only showing the 4 boundaries of the land and without disturbing the possession of any person within the boundaries. Within the boundary, not to disturb anybody's goods. They will only show the 4 lands. Who are they to give the land to somebody? You purchase the land from Mr. Bhattacharya. So it is your land. You go and go inside. Why will they hand over? Extra copies to delivery. Yes, what is this? Hmm. Huh? You filed it on 24/1/2026. So you don't file and immediately come back. Where's your application? You filed when? Issuance of separate patta. Have you got the patta? Have you got the patta? Then you got the patta after 24/1/2026. You are asking for sale permission. When did you apply? When did you apply? Ah. Okay, where? No. Very well. When you ask for sale permission, there is an acknowledgement number. No. Where is your acknowledgement number? Acknowledgement slip. No. That is not possible. Mr. J.I. Bobby, you bring that. Otherwise, no. When you apply, there is always an acknowledgement. There has to be an acknowledgement given by an acknowledgement slip that we have received this document. If it is done within certain date, this will be. And we don't know the date when you have submitted. Why should we? Why should we entertain today? The period is 60 days. The moment you apply, as acknowledgement is given. No, nothing will come out. No, there has to be an acknowledgement. And we are not going to exercise jurisdiction immediately. You don't come to the High Court immediately. 226, not possible. Sorry. To withdraw, come back after 1 month, 2 months. 2 months, after 2 months, you come back, we will look into it. But no. But this type of exercise of jurisdiction, you file it within 60 days, just not over, you immediately come before this court on 24/3. 2 months is over, you come. This is not the court which is going to look at. You have an appeal. You go there. we remind you to an appeal. Withdraw with liberty to come after 2 months, not before. We don't go as per age. And 72 years, people should not sell the land, they should preserve for the younger people. Withdraw, come after 2 months. Mr. J.I. Bonvial, the Learning Council submits that the petitioner would await for some more time. It means that the petitioner would await for for some more time, taking into account that the application was filed after 21/1/2026. 24 you filed. 24, no, after 24/1/2026. Taking into account the above, the instant petition stands closed on withdrawal. Liberty, however, is given to the petitioner to approach this court after a reasonable period, not prior to 2 months from today. It's agree. Why? So, you're going to Aizawl now. Are you going to Aizawl now? So, don't worry, we'll take up your matter whenever it reaches. Commission has violated the rights of the petitioners under Section 8B and 8C of the Act of 1952 while making the inquiries in respect to the combined competitive examination 2013 and combined competitive examination 2014. And thus the report 2013 and report 2014 are in violation to the mandatory provisions of Section 8B and 8C of the Act of 1952. The report 2013 and report 2014 cannot be used against the petitioners to initiate any disciplinary proceedings against the petitioners or any prosecution against the petitioners. All findings, observations, and or recommendations were made by the Commission in the report 2013 and report 2014 touching upon the conduct and reputation of the petitioners. Prejudicial cannot be used against the petitioners in any forum and are rendered non-effective as it violates Section 8B and 8C of the Act of 1952. The report 2013 and report 2014, subject to the observations made in clause 2 herein above, are not set aside and quashed. The report 2013 and 2014 contains various fact-finding details touching on matters of public importance, and such findings, observations, and recommendations may aid the government of Assam to retrospect as well as introspect and to take any policy decision for the future. The respondent state of the disciplinary authority could be at liberty to proceed with the disciplinary proceedings initiated against the petitioner on the basis of the so-called notices and the statements of allegation served upon the petitioner. However, the respondent state of the disciplinary authority shall not proceed with the disciplinary proceedings without relying and or referring to any observations, findings, and or recommendations made by the Commission, which touches upon the conduct and reputation of the petitioners in the report 2013 and report 2014. Accordingly, the second paragraph of the so-called notices, as well as the second paragraph of the statements of the allegations issued against each petitioner, stands stricken off. The extracts of the report 2013 or the report 2014, which are furnished as list of documents to the petitioners, cannot be relied upon. and or referred to by the respondent state of the disciplinary authority. In the circumstance, the disciplinary authority of the respondent state wishes to include additional documents and or provide the list of witnesses, the petitioners having already submitted their statement of defense have to be provided an opportunity to file additional statement of defense along with documents if so advised. The petitioner would be at liberty to raise such further or other defenses as permissible under law in their additional statements of defense. The liberty so granted in clause 6 herein above, the disciplinary authority of the correspondent state is limited to be exercised within 45 days from the date of the present judgment. It is observed that if the disciplinary authority fail to provide the additional documents and or the list of witnesses to the petitioners within the time stipulated herein above, the disciplinary authority shall proceed in accordance with law on the basis of the observations made in clauses 4 and 5 herein above. For the period of 45 days from present judgment, the disciplinary proceedings shall therefore remain stalled, thereby enabling the respondent state of the disciplinary authority to provide the additional documents and or provide the list of witnesses. This court, for the sake of clarity, observes that as the disciplinary proceedings against the petitioners are yet to be decided on merits, the above directions shall not preclude the disciplinary authority of the respondent member state to drop the present impugned disciplinary proceedings and initiated against the petitioner and initiate fresh disciplinary proceedings if so advised. It is observed that in the circumstance fresh disciplinary proceedings are initiated, the disciplinary proceeding authority of the respondent state cannot refer and or rely upon the observations, findings, and recommendations made by a commission against the petitioner in the report 2013 and report 2014. See, Devendra Narayan Pratap Singh versus State of Uttar Pradesh, reported in 1961, SCC Online, SC9. The liberty granted to the respondent state of the disciplinary authority to drop the impugned disciplinary proceedings and initiate fresh disciplinary proceedings shall be exercised within 45 days from the date of the instant judgment. Failure to do so, the respondent state of the disciplinary authority shall have to proceed with the impugned disciplinary proceedings in the manner directed herein above. The notifications whereby the petitioners have been suspended are not interfered with. However, this court directs the respondent authorities shall carry out periodical reviews as to whether the continuation of the suspension of the petitioner are necessary in public interest. It has been brought to the attention of this court that during the pendency of the writ petition, there were no reviews conducted by the competent authority. This court directs the respondent authorities to carry out a review of all the notifications notifying the suspensions of the petitioner within 45 days from the date of the present judgment as to whether the continuation of the suspension is necessary in public interest. Failure to do so would result in the notification suspending the petitioners invalid and the petitioner be accordingly reinstated in non-sensitive post, keeping in mind the observations of the Supreme Court at paragraph number 21 of the judgment in Ajay Kumar Chaudhary Supra. The petitioner, having given up the plea as regards the legality and validity of the parallel continuation of the departmental proceedings pending the criminal proceedings, it is observed that the petitioners are debarred from raising such contention in future. This court hopes and expects that the disciplinary proceedings so initiated against the petitioner are brought to a close at the earliest, taking into account that the delay in disposal of the disciplinary proceeding prejudicially affects the rights of both the petitioners and the respondent, but also leads to a state of uncertainty in the lives of the petitioners. Interim orders postally stand vacated. All interlocutory applications filed in the present proceedings stands closed in terms with the present judgment and all. There shall be no order as to cost.
Very grateful, my lord.
Why have you frozen? You have marked lien. That is okay. So you can very well mark that as lien and allow him and defreeze it. None appears on behalf of the petitioner on call. Mr. M. Sharma, the learned counsel, appears on behalf of the respondent number 1 and 2. The grievance of the petitioner herein is that the petitioner has a savings bank account number 3326015012224 maintained in the ICICI maintained in the respondent in the Uzanbazar branch of the respondent number 2. It is the case of the petitioner that in the month of October 2024, the said account of the petitioner, it's a demat account, no? How's the demat account? Huh? Case of the petitioner that in the month of October 2024, when the petitioner attempted to conduct a transaction in his savings bank account, an amount of rupees 10,620.26 was marked as lien. In addition to that, a further amount of rupees 2,632.45 was deducted from the petitioner's balance, which was already kept in lien. The grievance of the petitioner herein is that the petitioner savings bank account has been kept frozen for the last 2 years, more than 1.5 years, and it is under such circumstances the petitioner has approached this court. Mr. M. Sharma, appearing on behalf of the ICICI Bank Limited, submitted that the said bank has no objection. Submitted that upon instructions issued that the amount of rupees 10,600.26 was a proceed of a cybercrime. The lien have been, the said account of the petitioner have been frozen. Taking into account the above, this would have also taken note of that in various orders passed by the learned coordinate benches of this court, whereby there has been directions issued for defreezing of the accounts subject to keeping a lien on the amount which are proceeds of the cybercrime. In the opinion of this court, such orders can also be passed in the facts of the instant case. Accordingly, the instant with petition stands disposed of with the direction upon the respondent numbers 1 and 2 to defreeze the account of the petitioner and allow the petitioner to operate the said bank account, savings bank account bearing number so and so. However, it is observed that the said amount of rupees so and so, 10,000, shall be kept as a lien and would be subject to such orders, such instructions and directions issued by the by whom? By the Now, subject to the directions from respondent number 4, 5, and 6. Yes, what it is. Shifting. You within the rural, na? But we passed some orders to the effect, na? So what? Don't come up with this type of excuse. Go and complain to the Chief Justice. Same order we pass here. Two 94A. Let him file an application to the, you have filed that application. It shall be considered within this. Same order at page 56. What is wrong with the order? Who filed the appeal? You filed. And who was the person who filed the mutation application? Whether any portion of 5 acres remain in Rabban Ali's name available for inheritance mutation in 2020. You are Rabban Ali. You are the heirs of Rabban Ali. No. They are all the heir of Rabban Ali. So, what is your claim? Show me the ADC order. ADC order. 16A. Notice making it returnable on 15th of June 2025, 26. Petitioner, Mr. is Mr. Ambermore, UAP, he was on behalf of the respondent number one, Mr. Ambermore appears for respondent number 2, 3, and 4. Extra copies of the resolution be furnished to them during the course of the day. As regards the respondent numbers 5 to 8, the petitioner is directed to take steps by way of speed post by tomorrow. In addition to that, the petitioner is also directed to take steps by the way of the steel with the registry of this court and file an affidavit on service of the case of the petitioner hearing is that the petitioners have challenged the order dated 27/5/2025 passed by the learned Assam Board of Revenue in Revenue Appeal number 46 RA bracket B of 2024, whereby the order dated 21/5/2022 passed by the learned ADC Revenue Borpeta, whereby the order dated 16/8/2024 passed by the learned ADC by the ADC Borpeta ADC Revenue Borpeta was modified, and it was held that the respondent's hearing, private respondent hearing, would be entitled to mutation only to the extent of 2 bighas, 3 kata, 15 lectures of land. Huh? 2 bighas, 1 kata, 5 lectures of land. It is the case of the petitioner that the predecessor in interest of the private respondents hearing, namely late Rabon Ali, did not have any land. And as such, the question of granting any mutation does not arise. The private respondents hearing shall bring on record their stand by filing the affidavits. In addition to that, the respondent number 4 also is directed to bring on record as to whether there exists any land of land late Rabon Ali, which could have been mutated in favor of its successor in interest, that is the private respondents. The records of RA case number 12, the registry shall call for the records of RA case number 12. Okay. Very good order. Nature. Page 64. Page. Yes. But why should we entertain after this, after 11 months? Forget about that. You had filed the appeal. You knew about it. The appeal was dismissed. Then why should we entertain this for such a long? No. Absolutely no. You have filed the appeal. You are a proponent of the appeal there. You filed it after such a long time. Not a case. What natural justice? You are the person who have filed the appeal. You had to deposit, that is the mandate of law, or file an application for waiver. Did you file an application for? Understood. Did you ask for that? Then condonation application? No, no. Keeping a principal personnel hearing was granted where authorized to, and so he reiterated the submission made in the appeal. Then why didn't you go into that? Sorry, unhelp it. Why nobody is there in the CGST? You have not served copies. Oh my God. In that case, I think we dismiss it. Supreme Court may help you. Supreme Court. Division bench, you have very kind judges in the division. Judgments for the division bench. I think we dismiss. You know it when you file the appeal. That what are the prerequisites? First, when the amount is there, either you have to pay for the entire amount in full or not. You don't deposit. You don't file an application for waiver. No, wait. You did not file an application for waiver. Neither. You know that the delay has to be within, you have to file the appeal within 3 months and 1 month additional can be pardoned. You don't do that. For that 1 month, you don't file you file it in the month of October. Order was passed on that day, on which in the month of April, and you have received it on that very day. Then, are you showing that because of the ignorance of your counsels or the representatives, you are saying because of their ignorance, there is a violation of principles of natural justice? Absolutely no. You know the defect. Sorry that you had to file an application and you have not deposited. No. You paid after the order. After the order, and then after 3 months, you are coming before this court. 3 months. January you have paid. We are month of the year. Then February, March, April. Today, April, na? April, na? Then order passed in the month of October. No. Order passed on 28/4. You pay in the month of December. If Madras High Court, go to Madras High Court. They may help you. Not this court. Bombay, go there. They are very kind enough. I'm not. So you take a dismissal. You have our Chief Justice is from Bihar. He will also be very kind enough. They may do it. Not this court. Take the money. Let the money be taken over. You should know when you don't engage these people. No case. When a matter has been taken up, none appears on behalf of the CGST on call. List the matter again on 6th of April 2026, showing the name of April. Name has been shown or no? Showing the name here. List the matter again on 6th. Because it is observed that in the it is observed that on the next date, if the CGST the learned CGST is not present, this court shall proceed with the adjudication of the instant application in their absence. What? It's the counsel you have. Really, I should give you all the, I don't issue notice. My jurisdiction starts when I issue a notice. I don't have the jurisdiction till now. When I issue a notice, then only. I have not issued notice. So the question of stay does not arise. Yes, what is your case? Then yes, Mr. H. Sharma. That day this matter, you were showing some document on this matter. I could not pass the order on the ground that you were not present when the council. You say that this, on the basis of some inspector gossip to PS. Yes, what is your instruction in this matter? You got it. You should, you inform me. That day I said that I could have passed the order. I issued the notice, but I could not because he is not present. Now here this letter is being issued by the circle officer asking Dibapal Kakoti so and so for identification of the disputed land covered by so and so. So this is the direction given. Now why have you come, Mr. Counsel? There's already a direction on 19.912. Now this can only happen after the model code of conduct is over, isn't it?
Lordship,
So we do one thing, let's have the notice returnable on 18th of May. In the meantime, you, as their circle officer also seeks for demarcation. So go ahead with the demarcation and then we submit the report. But without disturbing anybody's possession.
because of their dispute,
Yeah,
because
but
of their
don't-
dispute, this is a
Yes,
request
we-
made
you
by the
carry out the demarcation, but don't disturb anybody's.
Lordship.
Issue notice making it returnable on 18th of May 2026. Mr. A. Bhattaji appears on behalf of the respondent number 1. Mr. H. Sharma appears for the respondent number 2 and 3. Extra copies of the petition be served upon them during the course of the day. As regards the respondent number 4, the petitioner shall take steps by way of speed post by tomorrow. The case of the petitioner hearing is that the petitioner, who is the power of attorney holder of one Nazibur Rahman. Petitioner is the power of attorney holder of one Nazibur Rahman. The petitioner has, on account of certain disputes between the said Nazibur Rahman with the respondent number 4, a request was made for for carrying out the demarcation of the land at measuring 4 kata 15.30 lessers covered by dark number 65 bracket new and in KP Patra number 41 new of village Dholboma, Moza Beltola in the district of Kamrup Metro, Assam. It is the further case of the petitioner that the circle officer dispute revenue circle had also issued an authority letter to the one Dibakar Kakoti LRA of lot number 2, along with one Rosoni Talukdar SK, to accompany the investigating officer of the case of Gorsuk PS GEDE number 60 dated 17/11/2025 and Gorsuk PS GDE number 35 dated 20/11/2025 for identification of the disputed land covered by dark number 65 of KP Patra number 41 of village Albama under Bentola Moza on 23/12/2025. It is the case of the petitioner that no such steps were taken. Mr. Ichana, the learned counsel appearing on behalf of the respondent number 2 and 3 submitted that in the meantime, on account of the model code of conduct being operational and the ensuring elections to the legislative assembly of the legislative assembly elections to the legislative assembly of the state of Assam, the officials are busy and such steps have to be deferred. So, taking into account the above, the respondents hearing, more particularly the respondent number 2 and 3, are directed to bring on record their stand by filing their affidavits. In the meantime, it shall not be a bar on the part of the respondent number 2 and 3 to carry out the demarcation of the land, measuring of the land, demarcation of the disputed land covered by dark number 65 of KP Patra number 41 of village Dalbama under Beltola Moza and submit a report along with the said and submit a report before the courts.
Their position shall not
It
be.
is observed that in carrying out such demarcation and or identification of the disputed land, the respondent authorities shall not disturb the possession of any persons in and around the said disputed land, within the disputed land. Who are the other people? These are two. Issue notice making it returnable on 6th of April 2026. Mr.
1, 3, 4, 5, 6.
Extra copies of the petition be served upon the learned councils during the course of the day. Let's tag the instant petition along with the PPC number 888-2026.
Page 123.
888/2026. Give your names out there, huh? Give all of your names with appearing for which respondent. Huh? You filed. File the rejoinder. You filed the rejoinder. Ms. So-and-so appearing on behalf of the petitioner submits that the rejoinder has been appointed, has been filed, taking into account however, filed today, taking into account that the said rejoinder is filed, let this matter be listed on 6th of May 2026. In the meantime, the registry shall bring on record the same rejoinder. What is the case? Mr. Das, what is the case? Yes, Mr. Das. Why should we exercise risk? Go before the land grabbing act. Who? Understood. Whatever may be, we go for land grabbing. Private respondents are party here. Okay, so we go for land grabbing act. That day we threw out the ACC. So why not? Why not ACC? ACC category. ACC was a party out there where there was a direction to prove them. Even the government can be land grabber. You know.
Before that, my lord, it was filed through an power of attorney holder. The case was filed through an power of attorney holder. I'd like to take a look at page 21, my lord. Okay.
Yes.
It says, my the schedule of the properties and open land measuring 3 bigas with buildings and sheds, no dark number, patta number. Under what authority, my lord, they can say that this is the dark of 28 patta 46. Schedule of the property, my lord, it says open land measuring 3 bigas. There is no boundary, my lord, and it's a case with regard to 2 biga 4 quarters. No boundary. The bills will be also pending as per the.
Who has filed this petition? Who has filed this petition? One of the power of attorney or the power of attorney? Now your attorney is faulty. Your power of attorney is faulty. Yes. I've seen it. It doesn't mention about which land. What is the land? What type of power of attorney? Madam, I hope you have not understood when Mr. Das is saying page 21 says about the schedule of the property.
It should not register.
How do we know that which property? Madam, I understand which that Which patta number? And why you not going to put this authority out there, in the land grabbing?
It's not in registered also. my lord.
There's a suit pending,
Suit also pending.
huh? We're not concerned with that. Michael Kinney, go there. Where's that thing to stay? Government. Paragraph. That's the need. Can the government direct somebody to stay in a patal?
No, my. It can't be moved.
Can't we? May allow some government land, it's a different thing. I think you need to go file the land grabbing. You can't do it. No, first of all, we are going to dismiss on this ground. It's filed by a person who has no locus standi.
It's a notarial, it's not a registered one also.
They said, for
Power of attorney, my-
petition, power of attorney, notary also, is good, but not this one. To dismiss. You can take instruction day after tomorrow to withdraw. But when it comes before me, otherwise, I need not allow you to take instruction for a dismissal. I'm not asking you to withdraw. I'm dismissing it. Because it is closed day after tomorrow. Because it's a Good Friday. Everyone sits on the holiday. So therefore. Okay, tomorrow we discuss it. We are done. Take the matter tomorrow at 2 p.m. Mr. Das just inquire whether you need to cook this thing at matter of time. Mr. FZ Mutunda, how many times Christians unveil none appears for the petitioner? FZ unable to file reply. Going on from 2025. Then why haven't you filed it? You have obtained some stay. What is your matter about? Cancelling the order of partition of land earlier passed on an application. So this partition is given under 100. 99 it is being given. You one time, but I have to observe something. Mr. Abdul Ahmed Magunda, the Lalit Council, appearing on behalf of the petitioner, seeks for an accommodation for filing a reply to the affidavit in opposition filed by the respondent number 3. It is noticed that the respondent number 3 have filed the affidavit in opposition on 15/11/2023. And on various occasions, the counsel for the petitioner has sought for time. Taking into account, it appears that the petitioner is not so interested for an early disposal of the petition. Accordingly, list the matter only upon the affidavit in reply be filed by the petitioner. If you don't file, it would never come. If you can't, it will come. Yes. What is their stand? Moment? Of the respond number 3. No, no. Yeah. Already received first piece money and the construction has already which will be for 24. Then
Present status, both petition number 1, both the last money released. Not info, but at least one time, they say I'm not eligible. But if you're not, also page 35. Page 35 are any. Page 32. Should be petition number 2. Is 32. But copy is. So what is also the consent, this is the house, but only the part.
from the stand of the respondent number 6, it appears that there is no denial to the fact that the petitioner number 1 and 2 are not entitled to the amount so claimed. And in that regard, Mr. Eborua, the learned counsel appearing on behalf of the petitioner, has submitted that the petitioner number 1 and 2 have already received 2 piece money and only 1 piece is remaining. However, as regards the respondent number 3, it is the specific stand is of the respondent number 6 that the petitioner number 3 is not eligible to sue.
Let's say we have filed our affidavit, so let's kind of see the page number 79 of our.
On the basis of an inspection report dated 22/12/2022, prepared by the Secretary, Dr. Dharampur Gaon Panchayat, with the remark, inverted comma, household who have got benefit under central of the state rural housing schemes, inverted comma, close. The learned counsel appearing on behalf of the petitioner drew the attention of this court to the affidavit in reply filed by the petitioner, wherein photographs as regards the house constructed of the respondent petitioner number 3 have been enclosed as annexure 3, annexure N to the said affidavit in reply. Miss Enbora, appearing on behalf of the Panchayat and Rural Development Department, shall obtain instructions on the contents of the said affidavit in reply filed by the petitioner, and more particularly in respect to annexure N to the said affidavit in reply. In addition to that, the Standing Counsel for the PNRD Department shall obtain instructions as regards as to when the third purchase money of the petitioner number 1 and 2 to be paid. This matter again on 1st of June 2026. What is the matter?
Here, we have filed one affidavit in both the cases. Some anomaly in the second case, Malata, I'd like to file one additional affidavit.
What is being challenged here?
Well,
What is challenged here?
yes. Lordship will find it, Malata, at page 58.
And just let me have a look at it. What is challenged here?
Page 58, ma'am.
What is the ground?
Continuous till page 81. 80 is the order.
You may have filed a reply. So what is the mistake here?
And the item number, Lordship will see, Malata, the 668 of 2023. That's like point out. The actual reply for this item will start from page 145. From Roman 4.
No, the question of, you see, you filing an affidavit in opposition in a matter of this kind
Otherwise, my lord, the
is
issue
not
order is
necessary.
clear.
It is not necessary. He has to count his case within the facts of the, as to whether it is more like a social jurisdiction, as to whether this court should exercise or not. But it is not a case wherein uh, you require your affidavit in opposition, because your affidavit, it has to be based upon what you have done.
It's similar, my lord, to the grounds given in the appeal, my lord. It has been quoted.
So there is nothing out there.
That part I leave it, my lord. Can it be immediately after the vacation?
Why? Matter pertains to what? So it will be seen from the industrial policy itself. We don't need the affidavit. We have the affidavit of the Commissioner of Taxes. They are the person who is denying it. So they're, huh? So therefore they accepted they are denying it. So they are denying it. So therefore you have not filed any reply. Mr. Dr. A.T. Todi, the legal counsel appearing on behalf of the petitioner, submits that the petitioner have filed an affidavit in reply today to the affidavit in opposition filed by respondent number 2. Taking into account the above, this matter again on 7th of May 2026, on which date an attempt shall be made to dispose of the petition. The registry shall bring on record the said affidavit in reply. The same order passed earlier shall continue till the next.
Can you file the affidavit on behalf of the industrial department also?
But, Mr. B. Gogoi further submits, the learned additional advocate general submits that for the industries department, the industries department of the government of Assam would also like to file an affidavit. The said affidavit be filed on or before 23rd of April 2026, thereby granting liberty to the petitioner to file reply on or before 5th of May 2027. In name of the pastor, matter is before me. The Hmm? one. Eight. Yes. And what about the other village? There it is verified here, na? Next two. Next two has the map. But it is pretty far away from there. So the other one, if it is affected, don't you think that you need to raise this issue before the Green Tribunal? Because it is outside your boundary. But you don't know also the boundary. No, no, you cannot. You cannot. No, no, Mr. Counsel, you cannot make that thing because you don't have the authority to do so. So therefore, if you have to say anything, it's Hmm. Huh? Page 36. Or checks. Yes. To me, HP. This is some power of attorney. Yes. In
fact, we have 5 affidavits. Court may take up the matter for final disposal on their hearing day. We'll
No,
place
I'm
our
asking
case.
you, my question is this, because the affidavit says it is 500 kilometers away from that site. Now, why the Jira compensation is being paid?
There was a survey and there was a joint survey where they were asked to appear. They did not cooperate because it is much beyond their village. In our affidavit, we have annexed all those documents.
Then why are you asking for payment of Jira compensation for this village?
Because that is, my instruction is that this is, council has not said anything.
This is the council's own letter. That is the 12th of April, 2024. Page 183.
Please, lordship.
183.
Maybe the last is 180. My last page is 180.
This is the affidavit filed by, I think, Mahabal, I suppose. Yes, Mahabal. Cements.
That affidavit I have to see, lordship, because my papers.
Yes. Yes. One 183 with reference, I have the forward there, the Jira compensation for this. Umrangso of 4 crores of so and so. It So kindly come to paragraph 7 properly. That the deponent begs to state that as per the resolution number 12 of the executing committee held on so and so in the conference hall of the honorable chief executive member of the Demarcation, the land measuring 3,000 square bighas situated all along the Gorompani Lonka road in between 26 kilometer and 29 kilometers, which was earlier allotted for establishment of the industrial estate, is hereby re-allotted to MS so-and-so at Umrangso for setting up of the plan. Therefore, the land which was earlier allotted to so-and-so, to cancel, because earlier you allotted 2,000. Now you have allotted 3,000. So therefore, it is inclusive of that. No, therefore, what happened is initially it was 2,000. Now they have increased it to 3,000. So are you saying that this 3,000 is not a part of the 2,000? My question is this 2,000 bighas, which was earlier allotted to Mahabad, which was cancelled, and another 3,000 bighas have been allotted, is outside the earlier 2,000? Where is that?
I will place records. The earlier 2000 bigha lands, there were some villagers, there was a PL, and the PL would have made a statement that we are not going to acquire them. That was cancelled, and this 3,000 has been a space plot, space parcel of land, where there is absolutely no villagers or no other villages. A part of that.
Where is that state?
That statement, Lordship, that is why it is a part of us, but today we are not fully prepared for the final score.
Oh, Mr. Secretary, you should know whenever the matter comes, you should be always prepared.
There, then it is not that
Don't
like
come
that.
to the
Lordship, when
impression of the.
we have a practice in the court that on hearing that, the hearing takes
With
place.
that
I mean, the
practice,
part of favor.
that practice, you
Then
can complain to
let them
the.
complete the whole argument. I will also make my argument. No difficulty on that.
Yes,
That's why I said that all the.
his only argument now is that his land is a part of it, of this 3,000. That's his only argument.
But our practice of the court, Lordship, is very important. When there is a hearing day or a matter is for hearing, then we come for final disposal and hearing. But abruptly, if Lordship wants to take it for final,
You are
we
not
become
ready. If you, Mr. Saike, if you are not ready to do the matter, then tell
I
us.
said at the very beginning that pleadings are complete.
No, that the pleadings are always complete. That is
It
an
may not be
immaterial for
possible.
that. That is, and this is not the practice which is being followed by this court. You may follow it in other courts.
Then
No.
Lordship may pass a appropriate order. I have no difficulty on that. Lordship may pass appropriate order. Lordship has heard them. So our case is that the total land which was given at the beginning, that 2,000 bigha, in terms of a PL decision, we have abandoned that plot of land where some jirats were there. So the council has taken a stand that we are not going to touch that 2,000 bighas plot. We have identified a separate plot of land in the same area without touching any of the villages. Now our last affidavit very clearly given that geo map, Google map. Now he is disputing that the Google map is not correct. If the Google map is not correct, then this is a case not fit for to be taken in a court under 226. They should go to a civil court. Lordship will kindly come to page 103.
Is this a Google map?
It's a Google, yes.
How can this
Google
be a
Earth map. Left hand side down below. Now he is disputing this. Let him come with an affidavit. In our affidavit, Lordship will kindly come to paragraph 2, 3. Page 99. Paragraph 2, I will read.
Okay, tell me, then,
Paragraph 3
No,
is very
then-
categorical.
no, wait, then what are the GPS coordinates for this particular village as maintained in your contemporary reports?
Then that factual aspect I'll have to acquire, and I have reserved my right to file additional affidavit. Whatever queries of this court
No, my
Your
question,
coordinates,
no,
everything will disclose.
Mr. Saikia, you say this is the part of the Google map.
Yes,
Now, in this very affidavit, you say that as regards the village, so to Lorfeng village,
yes,
you have delineated the boundaries.
Lordship.
But as regards Nobody Longporo village, you have not delineated the boundaries. This is your specific statement in the affidavit.
Paragraph 3, Lordship, may I read it?
Yes.
The deponent begs to state that as per the communication dated 16/1/1982,
Now, this is for the other one. I'm saying about paragraph 4.
paragraph 3, let me continue because
Paragraph
it's a
3
hearing, Lordship.
No,
I do not want to.
Mr. Counsel. Kindly see, paragraph 3 is already being taken care of at page 423. There's specific boundaries there. I'm not on that. Paragraph 3 is far away. That paragraph 3 is in respect to kindly come to page 424. Down
Now,
below.
Lordship will kindly see the last 3 lines of paragraph 3.
Ah.
The distance between New Toto Haleng village to the proposed allotment site of Mahabal Cement is approximately 3 kilometers. Now coming to the next paragraph now. The deponent begs to state that the boundary of the village, namely Nopti Nong Kupra, has not been delineated by the authorities of the North Kachar Hills Autonomous Council. However, the distance between the proposed allotment site of Mahabal Cement and Nogbi is about 500 meters.
So what is your basis? When there is no delineation. My question is this, as regards the other one, if you come to kindly come to page 423 of that same document. Now after that, annexure 1.
There's only one annex.
First page. No,
This is my affidavit. I am reading from my affidavit.
no, there is annexure 1. Kindly see, which is given out there. You have categorically mentioned as annexure 1. Page, yes, annexure 1.
Yes.
You see, as regards the other village, you have these 4 boundaries.
Along Long Kong.
Yeah, this is given in the year 1982.
Yes.
So therefore, those petitioners who come within these villages have no business. There's no business. As regards the other villages, if it is outside, my only question is, if you have not, you don't have you have not delineated the boundaries, which is your specific statement. How in annexure 2, you have this particular boundary in respect to this village? My question is this.
I got your question. Okay.
Nothing else. This is the specific, because the moment it is outside, then they let him go to green cabinet wherever it is. We are not concerned with anything else. We are
They
not
don't have
concerned
any
with
individual right at that point.
My only question is this, if it is outside, what business does this court have?
Let me get a specific.
Because here you categorically say that because you are saying about, because there has to be, for a purpose of Google Earth or Google Map, there has to be GPS coordinates.
I fully agree.
And if this GPS coordinates has to be on the basis of some contemporary document. Otherwise, nobody can say anything. So we need the instruction on 2 aspects. Put it on affidavit that on what basis is this annexure 2 made as regards this Nobody Longpura village. And secondly, whether the 2000 bighas which were allotted to Mahabal earlier, is a part of the 3000 bighas which have been now allotted. These are the 2 instructions.
Somewhere in our records, it is totally
We
different.
need to put it
That
on-
is why the PIL was closed at that point of time.
whatever may be, but this is the only thing.
Lord Lordship may frame the questions, we'll give a speaking.
This court have heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Mr. D. Saikia, the learned advocate general, appears on behalf of the NC Hills. Dimahasa or Autonomous? NC Hills? NC Hills Autonomous. assisted by Mr. R.M. Das, the Standing Counsel of the NC Hills Autonomous Council. Mr. E.P. Goswami, the Learned Senior Counsel, assisted by Ms. G. Goswami, appeared on behalf of the respondent number 7. Pursuant to the order passed by this court on 18/2/2026, an affidavit has been filed by the respondent number 4. At paragraph number 3 of the said affidavit in opposition, in the said affidavit, it is mentioned that the boundary of the village, Chotolarpheng, can be traced to the communication dated 16/1/1982 issued by the then Additional Secretary, North Kachar Hills Autonomous Council. And the distance from the new Chota Larpheng village to the proposed allotment site of the respondent number 7 is approximately 3 kilometers. This aspect is further shown by way of a sketch map obtained from the Google Earth as would appear from Annexure 2 to the said affidavit. It is, however, very interesting to observe that at paragraph number 3 of the said affidavit, it is categorically mentioned that on the basis of the communication dated 16/1/1982, the boundary of Chotolarpheng village was delineated on the basis of the communication dated 16/1/1982. On the other hand, at paragraph number 4 of the said affidavit, it is mentioned that the boundary of the village, namely Nobdi Longkuru, is yet to be delineated by the authorities of the North Kachar Hills Autonomous Council. It is further mentioned that a proposed allotment site of the respondent number 7 were mentioned that the distance between the proposed allotment site of the respondent number 7 and the Nobodi Longpuru village is 500 meters. Be that as it may, it is seen from Annexure 2 that the boundary of the Nobodi Longpuru village is also mentioned, is also reflected in the sketch map which is prepared in Google Earth. The counsel appearing on behalf, the learned counsel appearing on behalf of the petitioner submits that if the Nobodi Longpuru village is at a distance of 500 meters from the proposed allotment which was made in favor of the respondent number 7, then what was the necessity for the Additional Secretary Revenue to write a communication to the director of the respondent number 7 on 12/4/2024, seeking payment of the Jirat compensation to the tune of rupees 4 crores 94 lakhs 54,000. The learned counsel further referred to the assessment of the Jirat, which was enclosed to the said communication dated 12/4/2024, and submitted that this Jirat compensation specifically was in respect to the village Nobody Longkru, bracket 26 kilometer Umrangsu. Mr. P.K. Goswami, the learned senior counsel, drew the attention of this court to the affidavit in opposition filed by the respondent number 5, filed by the Secretary Revenue, Secretary Revenue Department, Demolition Autonomous Council in PIL number 49/2024, and specifically referred to paragraph number 7 of the said affidavit, wherein it is reflected that a meeting was held on 5/9/2024 of the Executive Committee of the Demolition Autonomous Council, and in terms with the resolution number 12, land measuring 3,000 bighas situated all along Gorampani Lonka Road in between 26 kilometers to 29 kilometers Umrangso Dimahasau, which was earlier allotted for establishment of the industrial estate, was re-allotted to the respondent number 7 for setting up of the cement plant. The learned senior counsel, appearing on behalf of the respondent number 7, therefore submitted that the assessment, the communications which were issued by the secretary, by the additional secretary revenue to the director of the respondent number 7, was in respect to the earlier allotment made in favor of the respondent by the office letter dated 2nd of March 2024, which was in relation to 2,000 bighas of land, which was cancelled. So in that regard, therefore, the learned senior counsel submitted that the 2,000 bighas of land which was earlier allotted to the respondent number 7 may have been a part of the Nobody Longkru village. However, the 3,000 bighas of land which have been allotted to the respondent number 7 in the meeting dated 5/9/2024 is outside the say 2,000 bighas of land which was earlier allotted. Mr. Disseminate, the learned Advocate General, appearing on behalf of the State the Demarcation Autonomous Council, further submitted that in view of the PIL dated PIL number 49/2024, the allotment which was made earlier on 2nd of March 2024 in favor of the respondent number 7 was cancelled, as there were inhabitants therein and there was a question of payment of Jirat compensation. Subsequently, a decision was taken to allot 3,000 bighas of land to the respondent number 7
Out of 600 bighas of land allotted to the industry department for an industrial scale. So these 3,000 has been culled out from a land which was allotted to industrial department out of 6,000.
That is there. I'm not on
My
that.
submission.
No. This 3,000 bighas of land is an area where there are no inhabitants, isn't it?
Not in, and this was.
And there was no requirement of
part
payment.
6,000 bighas plot of land.
And that there was no inhabitants, and as such, the question of payment of Jirat compensation would not arise. The learned Advocate General further mentioned that these 3,000 bighas which have been allotted to the respondent number 7 is a part of the 600 bighas, 600
600 bighas land for
Six-
establishment
600
of
bighas of land which
and-
was specifically reserved for the industrials department.
industrial estate to establish an industrial estate to the industries department and NC Hills Autonomous Council.
Industrial estate was earlier the part of the industrial estate. Is 600 or 6,000?
6,000
6,000 bighas of industrial estate
for
of the
establishment
land
industries.
of the land reserved for the industrial estate of the NC Hills Autonomous Council. From the above, the question therefore arises for consideration is twofold. First, as to whether, as to one, what, as number one, as to on what basis the sketch map of Nobody Longkru village as appearing in Annexure 2 to the affidavit filed by the respondent number 4 on 11/3/2026 have been prepared. In other words, whether the said map is being prepared of the Nobody Longkru village on the basis of GPS coordinates, and if so, whether there are contemporary records for the said GPS coordinates. Number 2, whether the 3,000 bighas of land which have been allotted to the respondent number 7 in the executive committee meeting held of the NC Hills held on 5/9/2024 is a part of the 2,000 bighas of land which was earlier allotted to the respondent number 7 by the office letter dated 2nd of March 2024. In respect to the aforesaid queries, the respondent number 4 is directed to bring on record its stand by filing an affidavit. List this matter again on 6th of May 2026. The affidavit be filed on or before 4th of May 2026. How long it is going as regards the demarcation? Demarcation proceedings completed. Mr. Das, demarcation proceedings completed? No. Fencing going on? Going. Huh? It has been submitted in the next heard Mr. P.K. Goswami, the learned senior counsel, assisted by Ms. G. Goswami, appearing on behalf of the petitioner. Mr. R.M. Das appears on behalf of the Demolition Autonomous Council. So it has been submitted that almost 90% of the demarcation, along with the fencing is also along with the fencing work has been completed. So list this matter again on 9th of 5th of 6th of May 2026. Yes.
That have this time to use the proof without limit of that. But the basis for computing is that then they have come across some production statement and some dispatch. What production statement, what state register, they are referring to some activities that propose to do. They have not supplied that problem. I do not know what they are referring, but nevertheless, I furnished my reply and that production dispatch which they are talking about is pertaining to the 3 months of the COVID year, April 2020, May 2020, and March 2021. These are the 3 months. They discovered some production statement and deviation which they are talking about. It is not part of the record. So they have not supplied a copy to me. I have subsequent to the passing of the order for the filing of the appeal. At the appellate stage, I requested for those copies to be able to they did not continue. Copy of the same to me.
But did you raise that as the ground of objection in your memo of appeal?
In the name of appeal, it is not.
That means we're now developing it, then afterthought. Let's not go into that if you have not raised that as the ground of appeal. We are on the I think we are sitting out on a second appeal. So here we'll only see what is the only on the pushing of law, nothing on and not on the basis which you have not raised. You had the chance in the 107 to raise that issue.
That for 3 months, madam. To say that this is the production statement, this is the dispatch. And they have what is the basis of their that we should have defined production for each month. They say that this is the standard of the electricity, and this is what I am going to. So comparing the industry standard with my production for the entire year, they have presumed that this is my production and this is my actual production. And on that basis, they have placed the demand for the entire year. For the months which they are saying that this is a production statement of this bad nature, I given a submission that it was a big COVID period. It was a lockdown the entire year. There was a production estimate which was prepared, which could not follow the target, could not be achieved. So it is not that that was the actual figure. In any case, nobody was nobody's statement was taken. That who is the author of that particular statement which they are talking about, all this. They had ample power under section 70 to take anybody from my factory. There was a survey in my factory. So no such statement was taken from anybody about the author of the statement and what is the discrepancy between the production and the production statement and my books of accounts, which they are saying that there is a discrepancy. Secondly, my lord, they did not do any stock verification. Supposing I'm in the habit of removing stock, removal. There will obviously be some discrepancy between my physical stock and the stock as per my book of account. No such exercise was undertaken. They are saying that we have told books is going so bad. No customer was investigated. They are saying that they are not given the details of those vehicle, but they are saying that there are details of the vehicle number available with them. No transporter.
Are you saying there was no investigation carried out on the 666? There was no investigation carried out.
No investigation. They have come to the conclusion of the clandestine work. On the basis of the LA's production statement and dispatch register, I do not have the copy. It is not part of the proposed notice either. But
that you cannot raise that issue.
Yes, madam.
You cannot raise that issue. Now my question is whether what was the
No, I raised it. I stated in my reply that this is my production estimate, not my because it was COVID period. I submitted that.
Did you submit that you were prejudiced on account of these documents were not made available? Did you submit that on account of these documents not being available, you were prejudiced?
No, I did not say that. I said that.
So don't raise that issue here. Here is the question is, if they had carried out an investigation on the basis of the investigation, what is the fallout out there? How they carry out the investigation, whether it is done and whether the appellate authority found the investigation in accordance, unless you show perversity out there, can't help you. Therefore, come to a point of perversity.
But I'm saying that I am a integrated cement plant. Integrated cement plant means I'm manufacturing clinker. Clinker manufactured from the limestone is the brand. From that, the first mistake is manufacture clinker. There are one of cement plants which just manufacture clinker, does not further convert it into cement. There are cement plants which manufacture cement, buys clinker from other plant. Because suppose there are area, for example, in my state, West Bengal, there are no limestone mine. So, say Ultratech cement factory there, they will bring clinker from outside the state and manufacture cement in the state of West. Not like that. So, because there are very limited states where the facility of availability of limestone is there. Here is the making state of the state of Assam, this limestone is available. So mine is an integrated cement. There is a manufacturing of clinker as well as cement. And in all probability, they have not given any basis as to how they have come to the conclusion of the standard production on the basis of electricity consumption, that this unit is consumed, then this should be the production. But for the timing, for even assuming that is correct, that will apply only to a standalone cement plant, not to an integrated plant like my plant, which is cement plus clinker. Moreover, cement plants are continuous plants because at a very high temperature, the clinker bearing limestone is burned. And thereafter, the chemicals are mixed, gypsum and other chemicals are mixed to convert it to clinker. And then from clinker also again to convert it into cement, chemicals are mixed and at a very high temperature of more than 1000 degrees centigrade. But the furnace are heated up. So that heating, that cannot be put down and heated just like that. So in the COVID period, the desired, but the production was not achieved. It is up 2021 year. And 3 months, the second so-called notice is for 3 months. That is April 21, May 21, and June 21, which was also COVID. I was in the habit of under estimating or under reflecting my actual production, the books of accounts, those kind of statements they've been available for every month. I've been maintaining that fake register for each and every month, not for 2 or 3 months only. So my submission was twofold, that it was a COVID period. I could not achieve the desired production level which I intended to achieve. And therefore, the figure that you are coming to is not the correct figure. They are not my actual figure. And they did not do any further inquiry from my office, from my factory regarding that whether I have displayed got goods or not. No inquiry from customer, no physical verification of stock. They are talking about the cash payment to some parties, but that cash also, nothing was discovered from my premises that say huge amount of cash lying in my premises. But if I'm in a regular habit of clandestine removal, cash will be discovered, there will be no match of.
Mr. Counsel, are you suggesting that the cash you will keep it inside your chamber in your premises, not in your house?
Where it will be kept in my residence of I might say somewhere. Yeah. Or my lord, my stock to maybe remaining.
Was there any search conducted in your house?
What?
Was there any search conducted in your house?
That
In the house of the directors?
the search was conducted at the practical.
So, that doesn't mean that you may not keep it in your house. What is this cash will? Let us not go into the cash available. That is an income tax issue, which will. But here we are coming to page 79. This is what has happened, paragraph 3. Since the seized accounts of the record statements have revealed that a substantial quantity of cement produced and supplied thereof were not incorporated in regular
Page 80.
page 79. Cement produced and supplied thereof were not incorporated in the regular accounts, and there is a pattern of some omission which is apparent manifest from the details mentioned above. It appears it becomes imperative to make an analysis of the power consumption vis-a-vis the production of so and so. Power consumption units is this much. Units has increased, but there is a decrease in production of cement. The machines must have gone bad. Power consumption have increased in units, not in rupees, in units. Have increased, but there is less in production. So COVID period, how can the power consumption increase? And Mr. See the period. 2017, 18, 18, 19, 20, 19, 20.
They have
We are concerned with which period?
in this particular petition, my lord, there is a 3 months period. April, May and 2021. I think the take up the 606.01 because that is the value for the entire period 2020.
20?
2021. April 22, March 31. But I refer to the full book.
No. Let us see the main order. Where is the main order?
Adjudication order,
No. Appeal in origin.
appellate order, page 55.
Okay.
55.
Where is the finding? 2021, power consumption. COVID is there. COVID was there, but why the power consumption has increased?
Power.
Con-
I have to keep the survey birthday. Because
Even during lockdown.
some production has to be done. Was not at the back, but in family sector.
Is it? During this period from 15th of March 2020, the plant was functioning. When the entire thing was, the year was closed till June.
Some items were put into the essential category, that commodity category, and they were allowed to function. Even construction activities were going on. Because several these infrastructure projects were going on, so they were put into some this accepted category that they will function.
But what about 1920?
19 is not telling. That,
No, but there also there has to be a reduction.
that is that is not the subject matter of this particular.
Maybe, but they are looking into it in that angle that last 4 years, look here. It was 12,000 units, 12 lakh units in 1718, and the production was 30,000 metric tons.
Yes.
Whereas in 1920, it is 15 lakh units and the production is 19,000. In 2021, when there was a lockdown on all, the consumption units is 20, almost 23,000, but the production is just 14,000.
plant has to function. The output is not the same, but if the furnace is running, the electricity consumption will be there, irrespective of the amount of production that I do. The plant has to continue. So the electricity consumption is there if the plant is running.
But there is no product. So there is no production then. There is no production then. So when but you are saying the plant was running.
Optimal cap.
So the production has come down.
So suppose the furnace functioning. But
So when the production has come down or it's not at the optimal,
Yes.
wouldn't the power consumption also come down? Would it increase? My question is this: would it increase unless your machines have gone bad?
that is also one of the submissions that they became old. They met that submission also, that over a period of time, since they're becoming.
Anyway, so we do one thing. We'll have this matter. Yeah, but this interim order, you have not paid any amount.
But
How is it possible? Pay 50%. How will the state function? Pay 50%. Pay 50%. How much is the amount?
Tribunal was functioning, I should have paid 20%, and then the tribunal was not functional at that point of time. Even if the tribunal was not functional.
For that, it is okay, but that doesn't mean that we are going to give you 10%, 20% of here. How much it is total? Pay the tax. We'll look into as regards the confirm the goods of 5 crores, okay, months, so and so. Okay. 5 crores is the tax. Pay the tax. Interest and penalty will look into. Pay the tax.
But I have an alternate remedy.
Go there. Alternative remedy, go there. Understood, Mr. Counsel. Are you aware that this court is not aware that the appellate tribunal has not yet been constituted? That I know. But does it mean that this court is going to grant you a stay like this?
I'm not saying that, I'm saying, kindly say,
Pay the tax.
kindly refer to 100, so
The state of Assam is dying, no tax. What do you say, Mr. Gogoi? You need the money.
Yes.
Penalty and interest will look into it.
Kindly refer to section 112.
What does it say?
But it says that no appeal shall be filed against the appellant the state. A sum of equal to 12% of the remaining amount of tax is due in addition to the amounts paid under section 10 which has been admitted. So if I pay 10% of the disputed amount, it further says that where an appellant has paid the.
Mr. Counsel, this is not an appeal under 110. This is no, ma'am, no, Mr. Counsel. This is not an appeal. This is 226. It is my jurisdiction. How much relief I am going to give you? Not as per the act.
Is correct, but under section.
Pay the tax.
To my petition, my lord. Why
Pay the tax.
but
Interest
I
will
have
look into
referred
it.
the state petition, my lord.
Pay the tax. Are you not a functioning concern? You are functioning, na?
Consider, my lord,
You are functioning
but
concern.
I have.
How can there be a stay and no court
Petition, my government, I have said that I am filing, I have to file this petition because the tribunal is not functional.
So what? Go to the parliament, ask the central government to have it.
I can.
But that is not the lookout out here. You are asking this court to exercise 226. This court will only exercise 226 subject to this.
A order was already granted, my lord, on the ground that the tribunal is not functional.
So what?
Kindly consider, my lord.
Interim order passed earlier, if any, could continue till the next date of listing. Chalo, you don't want it, I'm not going to pass that order. When do you want it now? Let us have the matter for final disposal, but I'm not satisfied. No,
Kindly
no perversity. Huh? Okay. At a request for the councils, the matter would require further deliberation. This court have heard the learned counsel, heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. in both the writ petition and as well as Mr. B. Gogoi, the learned counsel who appears on behalf of the respondents. Mr. B. Gogoi submitted that there has been an inadvertent mistake in filing of the affidavit in opposition in Demarcation number 6668/2023, isn't it? 6660/2023. And he may be made to file an additional affidavit in that regard. So liberty is given to do so on or before 27th of April 2026. The petitioner would be at liberty to file reply thereagainst on or before 7th of May 2026. List this matter on 12th of May 2026 for final disposal at 2 p.m. Read that. Yes, Mr. I Hawk. What is this?
Take it now.
President.
Or market. Market.
So you are challenging an order of 27-6. Where is that order?
That is not the it's the appellate order.
Now therefore the appeal so and so submit by year to the Imam has been disposed of with a decision that the government will not interfere with the affairs of shifting of the private markets situated on private land.
Even the not the denied. The third correct.
No. Who appears here? Panchayat. No Panchayat Council. Yes, Miss Enbora. Nowadays, too, after the private huts or private market, you have made some amendment, no?
It's not private.
Then
Initially, not the it was upon the government land. That land eroded. That's why not that market was treated upon the private land. And now not the thereafter right. Just shifted the market upon the land. That's why not an agreement has been entered. So not the that agreement, subsequently that agreement has been cancelled out and going into.
who are you?
And the agreement was third, which I am with the
Why?
before shifting a market upon island on that land taken on a lease agreement on this something.
Then
So subsequently
now they want to move somewhere else.
no. Now not the fancy not the dissident has finance and taken not they have taken a stand or agreed by you lot. That market is the representative to part
So it should be in your place.
Yes.
So the lease should continue.
But the appellate firm is
No, this is not permissible. This type of things is not permissible.
blocking.
Jila Parishad, everything has to have their market only at the place where they have their own land. And it cannot be on private lands. And this is the thing which happened. Madam, you remember that cow market?
That's it.
Madam, you remember cow market when there was a huge fight between Mr. Kane Chaudhary, Ms. R. Chaudhary on this side, and on the other hand, there was some cattle market.
That's it. There was.
This cannot happen like this.
Uh,
Hello.
like the efficient is the fire what only for taking the and the liquid. As for notice into the disposal of holding of this land, but it cannot fire
not rich one. To get one of the level decided, our decided that this market is okay. You file a short affidavit, madam. Miss So-and-so appearing on behalf of the PNRD department submits that she has received some instruction and the same. The same instruction upon being produced, this court is of the opinion the same be brought on record by way of an affidavit, so that the petitioner would be have the opportunity to file any reply. So list this matter again on 8th of May 2026. In the meantime, the reply be the affidavit in opposition be filed by the year on or before 6th of May 2000. Yes, Mr. Akan.
Hello, I'm preparing for respondent number two, Asasa, on behalf of my senior RS. She, for some personal difficulty, she will not. I have the instructions, my lord.
No, you went to this. What happened? Twenty? Award has not been passed.
One 164 and 161 statement.
It has been brought to the notice of this court that the next date is fixed before the Assam State Legal Service Authority on 23/4/2026. Taking into account the above list, go this matter again on 29th of April 2026. Because of the Assam State Legal Service Authority, as the Assam State Legal Service Authority is taking up the matter on the basis of the Assam Victims Compensation 2000 Scheme 2012. This court would request the member secretary, Assam State Legal Services Authority, to keep in mind the period so mentioned at clause 5. Clause 5. Clause 5. Clause 5. Clause 5 of the said scheme. Yes. Mr. Mohan.
Yes, Mr. Nanak, I have received the affidavit. I am going to file the affidavit by tomorrow.
Okay, Mr. So-and-so appearing on behalf of the Mr. Dina, the learned senior government advocate, submits that the affidavit would be filed by tomorrow. List this matter again on 29th of April 2026. In the meantime, the petitioner would be at liberty to file the reply on or before 27th of April 2000.
This case I pray for some accommodation lawsuit. We are yet to file our affidavit lawsuit. The petitioner wants premature release on basis of some office memorandum lordship for good order and discipline. He has been on life conviction.
When you are filing it,
3 weeks time.
Mr. B. Chakraborty appearing on behalf of the learned CGC 3 weeks time for filing the affidavit in opposition. List this matter again on 25/2026. Affidavit in opposition be filed on or before 11th of May 2026. Liberty given to the petitioner to file reply if any on or before the next. Hey, this matter we take it on 6, na? List this matter on 6/4/2026. along with WPC number 888/2026. What? By the delay on the part of the AR, sale permission not granted. What is wrong? Why sale permission not granted? When did you apply?
Applied 1984.
Ah,
And it is also 25.
ah. When did you apply? They have issued some notice when? Notified that the properties indicated have been searched in the office. Why there is a delay? Yes, Mr. Sharma?
So we have not received any instructions.
Okay. It is only on there. List this matter again on 11th of May 2026. In the meantime, Mr. H. Sharma shall obtain the necessary instructions from the respondent number 3 and 4 as to why the sale permission have not yet been accorded to the petitioner. It is further observed that that pendency of the instant writ petition shall not bar in granting the granting the sale permission, if so permissible under law.
Lordship is fixing it on.
11, na? Instruction.
No, Lord. No instruction.
What is wrong? These
None of
people,
the cases, Lordship.
Huh?
Still purposes of, and we have not received any instructions.
Mr. Enda, you are responsible. You have not informed the authority.
Letter. We have sent the letter.
Which person is that who is not or better? Why no instructions is been provided?
Lordship, this case, Lordship, I think, he has to prepare an appeal before the deputy commissioner.
Why?
Mutation as because they. Because within a 60 days, it is to be disposed of. If not, in that case, appellate authority is the district commission.
No, my question is, you applied for mutation. Where is your application? Where? Where is the acknowledgement? Why has an appeal been filed? Why have you filed an appeal?
The notification
So there is a delay, so therefore you have come again here. Means the Assam Public Services Act has gone for a 6. Okay. No instructions have been provided to the learned counsels appearing on behalf of the state respondents, more particularly the respondent number 2 and 3, in spite of being communicated. Come. This court fixes this matter on 6th of May 2026. It is observed that if no instructions are provided to the state councils by the respondent number 2 and 3 in the meantime, this court have no other option but to seek their personal appearance, seek the personal appearance of the respondent number 2 in the instant proceedings. By PWD, your lane. What do they say? Okay, you file your affidavit. Mr. D. Chaudhary, learned standing counsel of the PWD, has placed before this court a set of instructions. It is the opinion of this court that these instructions be brought on record by filing an affidavit. Accordingly, list this matter again on 25/2026. The affidavit be filed on or before 11th of May 2026. Liberty given to the petitioner to file reply thereagainst. Practical hearing. Are they appearing on behalf of the water source department submits that she has received the instructions? And the affidavit will be filed. Mr. Revenue. What is your instruction as to any award has been passed in this matter? Because here, after filing of the said contempt, some payments were made. In that regard, learned counsel for the petitioner has drawn the attention of the court to the communication data so issued by the joint secretary to the government of Assam Revenue and Disaster Management, whereby an estimate of rupees 4,84,48,000 AR was approved. The grievance of the petitioner is that while making the actual payment, there has been substantial reduction. Now you have got some money. Have also alleged violation of 33 and 80 of the 2012, the 39. But madam, tell me, if you are saying 33 and 80 have been reduced, don't you think that you need to go out there to the reference court? Why should we? Why last time? No, this type of cases should be dismissed at the issue.
Absolutely, my lord, the fifth matter to be dealt with by the reference court. The only issue involved is, my lord, the quantification of
Who is your
the
senior?
compensation.
This, you are unnecessarily asking for time. No, this is not a case where we should invent issue notice. Okay, the counsel appearing on behalf of the petitioner seeks for an accommodation on the ground that her senior is not present. List this matter again on, when do you want the dismissal? After Bihu, 22nd? Have the Bihu peacefully on 22nd of April 2026. Mr. Bhuya, your house must be crowded, na? Yesterday, while signing the order, I could find around 800 people signing wakalatnama. Today, now this matter is another 67 signing wakalatnama. Huh? You would have been the pick person to go to the elections also. Are you trying your luck? No, na? What is this case? Hmm? Land have been allotted. Now you have been only asked to produce some documents.
They have submitted,
Then
but they have taken time and the people are coming, saying that it has to make. No, any, written order after our, this. Like, in the past few days, that's why,
Mr. Bhattacharya, file a short affidavit that you will follow the process. We complete it then. They would not come. It's a very difficult thing, getting them. They have taken a, what do you call, that elections are there. It's festivity mood. And they are very happy, both of them.
Because my lord, this notice, my lord, that election.
Now, that is understood. Now the question is, you can very well go ahead, but you do it as per law. That's all.
Yes, definitely, my lord.
So you just find a short affidavit. Because as of now, there is no notice. Why should I? They have only asked. So me passing that order would not be proper.
This is basically, my lord, an athlete.
Asking them information.
But asking the information and it is an
Information. So the
appeal in this kind,
information.
my lord.
So the government has become such like, when you ask for information also, they think what is wrong.
And my lord, please fail for certiorari in respect of the, my lord, rejection orders of their allotment. Their allotment said, their application, it is there, my lord. At page 20, pair number B, a writ of certiorari, why should not be issued? We're seeing the rejection orders dated 23/5/2024, passed in Mission Basundhara, NXR 5, and directing the
So
authority.
allotment has not been counted. It has been rejected.
And directing the concerned authorities to grant the petitioners with Miyadi land pattas. How can, my lord? More exercising jurisdiction under 226, my lord.
They are made, it pursuant to some of the, these also areas.
We consider everyone. The habit of Mr. Bhuya filing a consolidated petition of whoever it comes. Gets hold of all chicken, dog, monkey, everybody together and then bring it to the Jew. It's something like that. Here you have to come. Those persons who have been rejected is separate. Who is pending is separate. But all 69 are being brought together. And now you see that it is only for some and some are not. Now tell me. No, Mr. Bhuya, tell me as regards petition number 67, whether it has been rejected or allowed.
Because, my lord, prayer number B and prayer number
No,
C.
this type of thing should not do. I think we need to come up with the, because everybody will have a different cause of action.
Absolutely, because these two prayers appear.
And you have a technical, very technical opposing counsel.
Apparently, these two prayers are mutually.
Anyway, we will do one thing. We do one thing. You have only asked that. So there is no interim order. The order says that if you want to do so by following the due process. So therefore, nothing remains here. As of now, you do one thing, you file a short affidavit in the terms like it's given by a forest in Abdul Khalek and then bring those formalities and we close it and it will be forever everybody.
Yes, absolutely.
Let an affidavit be filed by the Revenue and Disaster Management Department in the instant proceedings. This matter again on 4th of May 2026 in name of the past earlier shall continue till then. Only that you just draw it, then I think we will do better.
Correct.
One of the intent of the.
No, I said in time order past earlier shall continue till then. Yes, Mr. M.I. Hussain. No instructions. Mr. N. Guns. Your friend has left you. No instructions? What is your instruction? No. এই এটা যে অর্ডার দিচ্ছেন নো ইনস্ট্রাকশন দেয় ভারত টেকনিক বাটা ঠিক করেছেন না নাহলে আপনি মার্কিং বলে কিছু the date is same itu date tu kuman disu so they fulfill the instruction only marking bole কিছু asking respondent number 2 and 3 huh?
11th of May.
It will look at me like 6 May 6 May they order only file it is the district commissioner aru respondent proposed. Where is it that you have no land? You have been allotted. Where is the allotment?
Look, I have also received some instructions. I have placed it not one month. Two orders I have placed, that is 22/10/2025. That is the order of petition.
Page?
Order dated 22/10/2025 in respect of the petitioner Abu Tahir. This is not issued by the the district commission, ADC. In public interest, the land has been acquired and whereas under section 3rd paragraph. This particular land, the land of the petitioner, my instruction is land. My
Land has been acquired.
land has been acquired. And several notices are given to them. The second bunch, kindly see. I have given two letters.
Okay.
In respect
Land
of
has been acquired from them.
land has been acquired and notices were issued. Kindly see order dated 3/1/2026. I have given the order dated 3/1/26 also in respect of petitioner number 1 and petitioner number 3. They are not responding, they did not respond to the notices.
Did not get any notice. That is on paper on.
The third, yes, third page, I have given. Third page I have given. In that bunch only third page. Yes, Malak. The person concerned went to their home, their place, notice was offered. Yes, notice was offered, they received.
But this is only in 2025.
Yes, in 25.
Or this happened on 22/10/2025.
25.
And this was given on 24/10. Okay. So therefore now you
Therefore,
have acquired the land.
we have acquired the land and kept the amount in the civil deposit because they did not respond. They did not come to take the amount.
Tomorrow, if this type of things happen, tomorrow you can very well say, you don't like me passing order. If the government may pass an order out there, we have taken your land and serve me the order, would it suffice? Where's the section three?
No, no, that
Where's the section three? Tell me, or section nine or section six, where is it?
the order is there. In the
No,
order.
no, Mr. Counsel. Here the question is how you go on the plea, whereas in pursuance to an action on the plea of Romeo issued by inviting representation requesting under requisition are there within time frame and after left of all the requisition is given. Whereas for the imam proceeding were taking over possession of the requisition land. So you did not take over the possession.
Now it is,
So the photograph is here.
that was in October. Now it
No, no, this photograph was there. So this order was passed on 22/10.
Yeah.
On 22/10, there was no order on that date. Possession was not taken on the floor. But because here he is sitting over that you gave it. Then we come to it when upon completion of requisition, then you went under issue notice under section 6. When did you issue that notification?
Lordship, I need some time.
Present.
Because of
You-
paucity of time, Lordship has
You
given me
get the
one,
time. Very well.
Lordship has given me, kindly see. This is not an isolated
You
plot of,
file an additional app.
this is not an isolated plot of land. 1,000 acres of land.
You, because here that order surprisingly does not contain a date.
I'll,
Why there is no date or against the notifications of section 3, 4, 6, 9?
this is an order passed by the EDC, the competent authority. I will produce the documents. Kindly.
These
consider.
notification have to and produce the gazetted notification, not this statement.
Lordship, kindly give me time. I'll produce. Kindly and kindly appreciate.
I'm giving you time. Don't
Kindly
worry.
appreciate.
Don't
Kindly
worry,
appreciate.
Mr. Counsel. I'm going to give you time.
Kindly appreciate. This
I
is
will
not an,
give you a time in the month of May.
this is not an isolated plot of land. 1,000 acres of land has been taken for this project. There are three classes of land.
Mr.
One,
Mr. Nath, we are not concerned whether you take 10,000, 10,000 or 2,000 or
No.
1 big house.
what I am
An
submitting.
inch of land, if you are taking, you have to follow the law. That's all. My only question.
Three types of lands are there.
I
One,
really like the order passed by this respect recently by the Supreme Court in Persem Singh. The question arose that initially when we mentioned about that amount for taking the land, if you imply solatium as well as the interest on solatium, the amount will only come to around 600 crores. But later on, we found that actually we made a mistake. It was around 29,000 crores. Supreme Court said, we are not concerned with the amount what is. You have to pay, you have to pay. You have to do the law, you have to take it as per law, you have to do it as per law. So I'm not concerned whether 1,000 acres or whatever. I'm not passing any stay. I'm not passing stay order also.
as per law, this
What is the interim order passed?
status quo lordship is there. Kindly see,
I didn't pass this.
no, that was the first order. That was the first order on,
Okay, you bring it on record by filing it.
but I'll file the affidavit. Kindly see.
The counsel appearing on behalf of the petitioner is given liberty to bring on record the documents which were placed in vernacular before this court by filing an affidavit along with translated copies thereof. Mr. Deenat further submits that the learned senior government advocate submits that in the meantime, the steps have been taken for the purpose, submits that pursuant to due acquisition proceedings being carried out under the Assam Land Requisition and Acquisition Act 1964. The land of the petitioner was acquired. And in that regard, further submitted that an order dated 22/10/2025 was duly served upon the petitioner on 25/10/2025. Isn't it? Because his photo is on 25/10.
It was offered, they refused. That is not the information.
Was served.
They said that they have not received. Yes, my lord, the photographs, the instruction is,
And
they were offered, they were tendered.
taking into account the above, is the opinion of this court that these very aspects be brought on record by filing an affidavit and thereby enclosing the gazetted notification in respect to section, the notification in terms with section 3(6) of the Assam Land Requisition and Acquisition Act 1964. As there is some reference to the in the order which was placed before this court dated 22/10/2025, issued by the Additional District Commissioner, which lists accordingly on 15th May. Such as the petitioner as well as the respondents shall bring on record their affidavits as directed above on or before 4th of May 2026.
May not be on fourth. Can you do it after sometime? Till fourth month to be possible.
Okay, let it be on 29th of May 2026. And petitioner as well as the respondents shall bring on record their stand, file their affidavits as directed upon on or before 18th May 2026. Liberty given to both the parties to file subsequent pleading if so advised. Interim order custodian shall continue till the next. What is this? What case is this? Gautam Roy Fan Club? What is this? No. What type of petitioner is this? Gautam Roy Fan Club? Fence Club? What? This one? Okay, where the matter has come. An additional affidavit has been received by the section. Taking into account that the petition is yet to be admitted, list this matter for admission on 18th of May 2026. Service upon the respondent number 6 being completed, list the matter for admission on 25/2026. Yeah, appearing.
Court matter has been complied, vehicle is released.
Okay. Can you see what type of order has been passed? What character and what has
Have you got the vehicle or not?
I have got, but I have to find out. If we have direction is clear direction. Release the and people all the supposed to be completed. But what the after 5 months when they has passed the order and it came into pending, they taking involved in the open. And that's why finding court and warning has been given. Just after receiving the amount, taking. Whether
No, madam, that is very incorrect because petitioner misled this court because there was a confiscation proceeding. It was never informed to the court that there was a confiscation proceeding.
What was the direction passed?
Yes, directions said release the vehicle.
We have released the vehicle.
We have released the vehicle. That's all.
Let's not go into what the order
Yes.
is.
Otherwise,
We are
he
not
may speak the
concerned
court.
that day.
And I'm just giving the.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. D. Gogoi appearing on behalf of the contemner. The instant application has been filed, alleging willful and deliberate violation to the order dated so-and-so, passed in so-and-so. Whereby there was a direction for release of the vehicle. Mr. D. Gogoi, the learned counsel appearing on behalf of the contemner, has produced the document, wherein and submits that the vehicle have been released. The counsel appearing on behalf of the petitioner also submits that the vehicle have been released. Taking into account the above, this court, however, is not the account above this court drops the instant contempt proceedings. If the petitioner is aggrieved by the contents of the order, the petitioner shall to be at liberty to take recourse to any other proceedings available. It is excludable. Service upon respond number 7 to 12 being not complete leaves the matter upon completion of such service.
This is also necessary.
It is said, it's a difference in service will come only a 7 to 12 is not complete. No, then place it before the registry. Master. I can't do that. Do I look like a Lozima court at 5 o'clock in the evening? Has not been completed. That is what it is saying. You go and place it before the Lozima court. Or, okay, the learned counsel appearing on behalf of the petitioner submits that as per him, the service upon the respondent number 10, 7 to 12 has been completed. Let the matter, the registry shall place the matter before the Lozima court within 2 weeks' time for necessary orders.
I'm seeking some more time to file an affidavit.
Huh?
I'm seeking a little bit more time to file an affidavit.
The instant petition has been listed before this court in the orders column on the ground that the respondent have not filed the affidavits. In terms with the order dated 11/3/2026. It is the opinion of this court that such matters should be listed before at the admission stage and not at the order stage, taking into account that if there is no affidavit filed, this court can proceed with the determination of the said proceedings. Accordingly, lists this matter on 18th of May 2026. Long date. Okay, on 4th May. On, huh? Extended. Is it in time order? On 4th of May 2026. The interim order passed earlier shall continue till the next date. Was that order passed? If award is the award has been paid, people are not getting. Okay, list this matter for admission on 7th of April 2026. We have it on 7, let's see. Interim order is there. Interim order shall continue till the next. Taking into account that the pleadings are complete, list the matter for admission on 6th of May 2026. Service complete. Okay, taking into account the office note dated 27/3/2026, this court observes that the service upon the respondent numbers 2 to 5 is complete. This is the matter for admission on 8th of May 2026. This is the matter for admission. 46. 46 or 44 order taken. Same order. 46 and 44. 5 and 6 is complete, no?
That's it. I am appealing for 6, that's it.
Okay. The service upon here is complete. As per the office note, same one, order to serve A to the book, খালি ইয়াত respond number 5 and 6, huh? Okay, this is the matter for here, I got one. 47? Same. Same, every admission, same order. 44, 46 and 47, same. Only you can what the second. Okay, matter over. What? Which matter?
Matter was the list of hearing, matter was sent for mediation. The mediation report has not come yet.
Oh.
Will be after vacation, when in the meantime, the report may come.
Any development?
I attended 3 occasions, but the municipal board, there was no representation.
It has been submitted that the, by which order it was sent to mediation?
19th of February, 2020.
By an order dated 19th of February 2026, the instant proceedings was sent for mediation. However, the report of the mediator is not placed before this court. The registry shall put a report, a note into that aspect in the office notes and place it before, put a note in that regard in the records and place the matter again before this court on 27th of April 2026 in the orders column.